Testing.
Good morning.
Welcome to docket number 241004, the application of the United Illuminating Company to amend its rate schedule. We are here this morning to begin our evidentiary hearings in this matter. We have an agenda in front of us today and a number of administrative matters before we get into the meat of the testimony this morning. So we'll begin by taking appearances. We'll start with the company followed by other parties and interveners at the mic, please. So to the company first, please.
Yeah, good morning, Commissioners. Dan Venora and Brendan Vaughn from the law firm King & Moreland on behalf of UI.
Thank you. Appearances from other parties and interveners, please. Attorney White.
Sorry. For the OCC, Kim White. I'm joined by Consumer Counsel Coleman, Director Tom Will, and Prabisha Bandari.
Thank you. Good morning.
Good morning. I'm Susanna Nigro, and I'm here on behalf of Deep.
Thank you, Attorney Nigro. I see Attorney Wright.
Good morning, Chairman. John Wright on behalf of the Attorney General, and with me today is Caroline McCormack as well.
Thank you. All right, we can keep it going here. Good morning.
Good morning. Jay Goodman of the law firm of Couch White LLP, appearing on behalf of the Connecticut Industrial Energy Consumers.
Thank you. Good morning.
Good morning, Tom Lopez on behalf of EOE, and I'm joined by my colleagues Brittany Wyman, Alex Sahi, and Jamie Spanhake.
Thank you. Anyone else? Okay. A couple of administrative matters. Commissioner Karen is under the weather and is watching on YouTube today, but Robin, he says he cannot hear. Okay. Okay. Excuse me. All right. So that's a good reminder. We are broadcasting next week's hearings on our YouTube channel. I'll ask that any folks who approach the mic from the audience, remember to please pause and make sure it is turned on, and ask the witnesses and the attorneys to make sure that your mics are on. I will have to interrupt if the mic is not on or adequately directed at any point. Please make sure the green light is on your microphone. Even if we can hear it in the room, it does not pick up on the broadcast. So we'll try to observe that throughout the weeks. All right, turning to administrative matters, we do need to establish our first late file exhibit pursuant to our customary practices. We will establish late file exhibit 1 to capture any errors or updates identified through the proceedings. So we'll mark that as late file exhibit 1 and revisit that before we adjourn our hearings. I think actually we only have one due date for late file exhibits marked as May 14th. So we do not have to adjust what I was about to think about with our rolling hearing dates. Okay. there any other late file exhibits that we need to establish from upfront? It's just late file 1. Okay. We will aim to take a lunch break at approximately 12:30. Depending on where we are in the panels, we'll aim for up to a 45-minute lunch break if we can swing it with the schedule, and we will take one 10 to 15-minute break in the afternoon at a minimum. In terms of additional administrative matters this morning, do parties and interveners have any other administrative matters? Attorney White.
Thank you. Fine. Yes, OCC has 3 minor administrative matters. The first is that Dr. Woolridge has a medical procedure scheduled for April 30th. It appears as if this won't be any sort of conflict. He is on the first panel with any sort of cross indicated for him. So we believe he should be able to go before them, but we wanted to call that to everyone's attention. The second administrative matter is we had conferred with all of the parties and with the case coordinator regarding Mr. DeFever. He was on 2 different panels, a comp and benefits panel as testimony, and then the revenue requirements panel. All of his testimony is going to be done in the second panel. So that way, since he's traveling from Minnesota, he only has to travel 1 day for that. Everyone had agreed to that, but I just wanted to call that to the authorities' attention.
Attorney White, you said the second panel he will
Yes,
appear.
ma'am. The comp and benefits panel was first, and that had minor cross that was waived or was deferred to the second panel.
Thank you. Just give me okay, so the second panel appears on page 12 of the agenda. Is that accurate? Okay, and the first panel appears on page 9, so we're crossing off page 9 to be handled on page 12. Is that
Yes,
accurate?
ma'am.
Okay. Okay, thank you.
And our final administrative matter was Richard Sobolewski of the Consumer Council staff sponsored one interrogatory after the agenda was issued. So we will bring him up with one of our panels for him to adopt that interrogatory response.
Okay.
Okay.
Is there a preference from the OCC or any parties? Is there cross on that interrogatory, or does it just need to be adopted?
It just needs to be adopted, or
Attorney Venore?
I don't expect we'd have any cross of Mr. Sobolewski.
Okay, thank you. Attorney White, you don't happen to know the first time you have a panel up, do you? Cost of capital, maybe?
our first panel is this, well, it's Dr. Woolridge, cost of capital.
Okay.
I'm not sure if, sorry.
Mr. Sobolewski, depending on the timing, sorry, Tom Wheel for the Office of Consumer Counsel. Mr. Sobolewski is currently at a medical appointment, but he will be in the building later today. So depending on the timing of when Dr. Woolridge is seated to testify, he could potentially join that panel. But otherwise, I believe our next panel after Mr. Sobolewski would be Mr. DeFever,
Okay.
which we expect to be far later in the hearing.
Thank you. I suspect I'll remember this if I see Mr. Sobolewski approach the witness table, but if you can just remind me to make sure we do that to begin with, and then we can excuse him. Okay. Thank you.
That's all. Thank you.
Other parties or interveners with administrative matters, I see Attorney Nigro approaching.
Good morning, Susanna Nigro on behalf of DEEP. With respect to the agenda, for the cross-examination of the environmental panel, we anticipate that the examination will be conducted by Attorney Sarah Solars and/or Attorney Brendan Shane on behalf of DEEP, and we were hoping to update the list.
You're hoping to do what?
Update the list, the agenda.
Of course, if you can just, you don't know what page that's on, do you? Page 14, the environmental remediation panel.
Correct.
Okay, Attorney Sarah Solars and Brendan Shane. Okay. Thank you.
Thank you.
All right, other administrative matters? Okay. I have one. The first question is for the attorneys of parties and interveners other than the company. So if that is you, if you can listen to this question, please, and approach the mic to respond on Thursday, April 24th, the authority received motion 103, which is voluminous, I think at 83 pages. I'm seeking a comment from parties or interveners regarding the amount of time that a party or intervener may need to respond to that motion. If you are a party or intervener who has a position on the amount of time needed to respond to that motion, I would ask that you approach the microphone. I am going to then set the deadline for responses to that motion to the close of business on Friday, May 9th, please. Okay, speaking of that motion, I have a few questions to pose to the proponent. So either Attorney Vaughn or Attorney Venora. We will obviously not be ruling on the motion today, but I have a few preliminary questions so that the authority can begin assessing. So the first question dealing with the request in that motion for recusal. Specifically, you're requesting a vote on the recusal request, but I don't see anything in the motion that supports the process. Do you have any case law or other legal citation that shows that the question of recusal is subject to a vote by the panel?
Our position is set forth. We have everything that we rely on is set forth in the motion in that regard.
Okay, thank you. Is that the same response to whether there's any case law or precedent regarding staff of an agency being required to recuse themselves as decision makers?
In that regard, the motion speaks for itself. We put our legal position and argument in the motion.
Okay, so no further case law or citations that you wish to add for the authority's consideration at this time?
I don't have anything else, for specifically for this morning, but the motion does speak for itself.
Thank
Anything that we have cited numerous cases, numerous statutes, numerous regulations in that motion.
Understood. There weren't any that were specific to the question that I just posed, so I wanted to make sure that we had everything in front of us. So the motion also alleges unlawful procedures, and I note that the company has filed a motion for reconsideration of motion 60. For the authority's clarification, is the company objecting to any other motion rulings at this time?
Well, any other motion, that's our only pending objection currently. And it's actually, we've filed a motion for panel review. So if you're characterizing that as the objection, that's our only pending motion relating to prior rulings.
Thank you. That is what I'm characterizing as a motion for reconsideration, is the request for panel review. So as we sit here today, my question is the company objecting to any other? There's been around 100 motions issued and that the company is in receipt of. So I just, for clarity of the record, was hoping to understand whether the company is objecting to any other motion ruling at this.
No, that's our only pending motion and only pending objection to a ruling.
Okay. Thank you. Okay. I suspect the answer to the next question will be similar to what you've offered already, but I do want to ask the motion on page 7, I believe, makes the assertion that I specifically have prejudged facts in law with respect to the rate application that's now pending before PURA. So to the extent that the motion does not speak for itself, the question to the company this morning is if there is anything further you want to opine on with respect to specific adjudicative facts or questions of law that have been prejudged, or does the company intend to rely on the motion as submitted?
No, we rely on the motion as submitted. So I'm not really clear on what else, you might be alluding to, but everything in terms of the company's legal position has been put forth in that motion. And I'm just pausing because, in terms of your prior question, does the company have any other, pending objections on motions? I mean, the company has in that motion for recusal set out, and also in the motion for reconsideration has set out a challenge to the use of the executive secretary letter rulings. So there is, in that regard, there is a general standing objection to the use of that practice. So, and anyway, that, in terms of like pending motions, we have our motion for reconsideration, but we also have our legal position that's set out in those, the two motions, the motion for recusal and motion for reconsideration.
Thank you for the clarification. So just to make sure I understand, the company's objection is to the process, but not to the ruling disposition. I think we want to make sure, as we're sitting here, you have one pending request for the authority to reconsider one specific motion ruling.
Right.
And the question is, there are 100 motions that have been received and ruled on. So we'll want to make sure that the authority understands whether the company is objecting to the disposition of those motion rulings and is thus asking for the authority to reconsider its rulings on any other motions.
No, just to be clear, we object to the process, not to those rulings, except for the rulings that we have challenged on the motion for reconsideration.
Okay, so you object to the process, but not the outcome.
Right, right. We object to the process as for the reasons stated in our motion for recusal and in our motion for reconsideration.
Okay. All right, thank you. I believe I'm clear, and so unless you have any questions, I want just, yes, sir.
Mr. Chairman, Commissioner, I'm sorry I was a moment late, but I do have a couple of administrative matters. Tim Wilkerson for NECTA, New England Connectivity and Telecommunications Association. Again, my apologies for coming in late.
Attorney Wilkerson. Okay, thank you. Administrative matters with respect to motion 103 or
No.
separate?
Generally.
Okay, then that's fine because I believe I am done on motion 103. So Attorney Wilkerson.
Thank you. NECTA intended to reserve 2 hours for cross-examination for the poll attachment panel, but inadvertently was added to the poll rates panel. Please shift NECTA's costs from, cross from the rates panel to the poll attachment panel. Attorney Dave Suter, my colleague, did reach out to the case coordinator on this point. All of these points, actually.
Okay, so you should be on the panel on page 18 labeled poll attachments is your position.
Yeah, shift
Next,
from the rates panel to poll attachments panel. Yes, that's correct.
The rates. panel. Okay, I see. So on page 15, where it says Dave Suter, should be on page 18.
Correct.
Thank you. The next item?
Secondly, NECTA waives cross-examination of each of the other panels.
Very good.
Third, Scott Thompson of Mintz Levin will be conducting the cross-examination of the poll attachments panel and the direct of NECTA's witness, Patricia Crafton.
Can you state his name again, please?
Yes, Scott Thompson of Mintz Levin.
Okay, has he entered a formal appearance into the docket?
He has.
Thank you.
And I should note that Attorney Dave Suter was going to be present throughout all of these proceedings. He has been deployed. He's in the Army Reserves. He's been deployed to CENTCOM down in Tampa until the end of September. So I will be once again appearing before you. And it's been a long time, so it's great to be back.
Thank you. And thank you to Attorney Suter for his service. I believe I've caught that. Just the note for you and any other party or intervener in the audience, if when I'm going through the agenda, if I do call, if we have you inadvertently listed on the panel and I call and you aren't here, we're just going to we'll move on to the next person. So no issue, but I think I've got that.
Thank you. And then one more, Patricia Crafton, who is our expert witness, is unable to testify on May 5th, just for planning purposes. I wanted to flag that for the two of you and staff.
Okay. Which is Monday, right? Okay. Not available. So page 19 is not available May 5th. Okay, thank you.
Thank you.
Anyone else?
Chair Gillette, I appreciate your comments earlier about the lunch break. We do have a big group. So if we could get close to the 45 minutes, that would
Absolutely.
be very helpful. Thank you.
We will do our best. I just don't want to say exactly 45 minutes if
Understood.
it's 40, 42. Understood. Okay, so we are going to move in just a second to the into our first panel, unless there's anybody else with administrative matters. I do want to just disclose, I want to close the discussion this morning before we move into the meat of the panels with a quick observation regarding Pura staff in particular, and want to note that the staff of this agency are experts in their field, and I'm proud to serve as a commissioner alongside them each and every day. Look forward to these hearings. Commissioner Arconti.
Thanks, Madam Chair. I just want to echo that to our staff. Honored to be your colleague. Thanks.
Thank you. So we're going to move into our first panel this morning, which I believe is entitled Case Overview and Regulatory Policy. I believe we have our three witnesses. So Attorney Venor, Attorney Vaughn, whomever will be introducing the witnesses, and I will swear them in before we adopt any pre-filed materials.
Good, thank you. Good morning, Chairman Gillette. To the panel members, would each of you please state your full names and positions for the record?
Good morning, Dan Canavan, Vice President Regulatory Affairs for UIL.
Andrea Van Luling, Networks Controller here on behalf of UI.
Good morning, Chuck Hughes, Vice President of Electric Operations for UI.
Thank you. If the witnesses could please raise your right hand, I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you. Attorney Vaughn.
Thank you. Mr. Eves, Mr. Canavan, and Ms. Van Luling, as part of your preparation for this docket, did you provide a pre-filed direct testimony, which was marked as Exhibit UIRRPP1?
Yes.
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 And Mr. Eves, did you also co-sponsor direct pre-filed testimony and exhibits in this proceeding, which were marked as Exhibits UI, EOP 1 through 5, and UI CIP 1 through 11?
Yes.
And Ms. Van Luling, did you also co-sponsor direct and rebuttal testimony and exhibits in this proceeding, which were marked as exhibits UI RRP 1 through 27, UI rebuttal 1 through UI rebuttal 5?
Yes.
Thank you. And to the panel, did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes. No.
Yes.
Yes.
Thank you. And Ms. Van Luling, do you have any updates to either your interrogatory responses or your initial testimony since it was filed on November 12th, 2024?
Thank you. We do have updates to the testimony. So subsequent to the filing of the testimony, we did file the ROEs, the return on equity filings for December 31st, 2024, in which UI distribution had a 3.55% ROE for the full year ending December 31st, 2024. In that same filing, the cost of debt is 4.64. So UID's current ROE of 3.55 is less than the cost of debt of 4.64. And as stated in our testimony, as well as some other testimonies, it is really critical that the equity return is higher than a debt return, since equity investors take on a much higher level of risk than debt investors. Also, as mentioned in our testimony, UI's credit metrics were moved from stable to negative, consistent with the testimony, but subsequent to that, UI's sister companies, CNG and SCG, both received downgrades in their credit metrics. CNG received a 2-notch downgrade and SCG received a 1-notch downgrade subsequent to the rate case proceedings that those two entities had. We've also had notifications from the credit agencies on the stable to negative outlook that they're continuing to monitor UI, and that they could make updates subsequent to the rate case that could occur 12 to 18 months after the rate case. In addition, as we describe in our testimony, in order for UID to earn its allowed return from the last rate case, 220808, it would need to have $54.8 million of net income. The December 31st, 2024 net income was $27 million. So there's a $27.8 million variance between what we needed in order to earn the allowed ROE and what the actual results were. You need to gross that up for taxes. Once grossed up for the tax for federal and state tax rates, we would need an additional $38.4 million in order for UID to have met its allowed ROE. That $38.4 million is higher than employee compensation as a whole, corporate services costs as a whole, UPZ costs, or veg management costs, therefore making it impossible for UID to have cut costs for $38.4 million to earn its allowed return.
Excuse me. Thank you. Mr. Eves, has the company continued to maintain capital expenditures at a reduced level?
It has. So the company, based on the outcome of the 22 rate case, was forced to reduce capital expenditures to about half of what we believe is necessary to support customers and the service they've come to expect from us over the long term. In doing that, we prioritized the work that we do to support customers on a daily basis. So connecting customers, doing state projects, restoring power. What we were forced to do was to defer some of the investment that we make in aging infrastructure in our fleet, in things where we have some margin in the short-term operating performance of the system, but that will have impacts long-term.
Thank you, Mr. Eves. Is the company focused on the affordability of its proposal in this case?
We are the direct conduit to customers, so we are keenly aware of the impact that what we do has on our customers every day. But we also provide a service that's essential to modern life, and the cost of providing that service has increased over time. The things that we propose in this case are necessary, and the idea of deferring them or not doing them simply builds a bow wave into the future. So at the end of 2024, we've pushed $70 million worth of need into the future. By the end of 2025, that need will be $150 140 million. In a decade, it will be 700 million. So at a time when we are preparing to address the transition to electrification, we will have a significant bow wave of need that we have built up. As we did our analysis with our plan under the RE08 framework as well, what we found that based on that framework, our plan is affordable.
Thank you, Mr. Eves. And Mr. Canavan, what does the company seek as a reasonable outcome to this case?
Yeah, thank you for the question. We think a reasonable outcome in this case includes the following: recovery of actual and planned plant additions, a reasonable recognition of increases to our O&M expenses, a reasonable ROE, and a rate plan that allows the company a reasonable opportunity to earn that ROE, and the recovery of deferred expenses.
Thank you. And to the panel, subject to these updates, do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Yes.
I do.
Thank you. The panel is available for cross-examination.
Thank you. Does the OCC have any cross for this panel? Thank you. NECTA. Attorney Wright. Thank you. Attorney Nigro. Thank you. Attorney Wyman. Thank you. Any questions for this panel? Thank you. I also do not have questions for this panel. Thank you. Move into our second panel, which is listed as the interim rate application panel. I believe we have the addition of one or two witnesses. Okay. Once they're seated, Attorney Vaughn, if you could introduce the new additions.
Mr. Panici and Mr. Hurwitz, would each of you please state your full names and positions for the record?
Yes, Michael G. Panici. I'm the Vice President Treasurer.
Jacob Hurwitz, Senior Director of Revenue Requirements, here on behalf of UI.
Thank you. Gentlemen, if you could please raise your right hand, I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you. Attorney Vaughn.
Thank you. Ms. Van Luling, Mr. Eves, and Mr. Canavan, you were previously sworn in, but as part of your preparation for the company's application for interim rates, did each of you co-sponsor direct testimony that was marked as Exhibit UI VCE Interim Rates 1?
Yes.
Yes.
Ms. Van Luling, Mr. Hurwitz, and Mr. Panici, as part of your preparation for the company's application for interim rates, did each of you co-sponsor direct testimony and exhibits that were marked as Exhibits UI VHP Interim Rates 1 through 3?
Yes.
Yes.
And Mr. Eves, as part of your preparation for the company's application for interim rates, did you sponsor direct testimony that was marked as Exhibit UI CJE Interim Rates 1?
Yes.
Thank you. And did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
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 Thank you. Mr. Hurwitz, do you have any updates to your testimony since it was filed on November 12th, 2024?
Yes. As Ms. Van Luling described a few minutes ago, UI's earned ROE has continued to fall since the time it filed its request for interim rate relief in November of 2024. And the UI, like other regulated utilities in Connecticut, continues to experience credit rating challenges. UI previously sought a request for interim rate relief in November of 2023, and PURA rejected that request for, as I understand it, two reasons. First, PURA found that UI could not peer into the future and that its request expressly relied on prognostications regarding what would happen to UI's financial health. And in that filing, UI had anticipated that its earned ROE would not exceed 5.6% based on the rate increase that was authorized in 220808 and UI's financial condition at the time. Pura also rejected the request because it was not made in the context of a general rate proceeding. Now, both of those concerns appear to have been resolved. The concerns UI expressed, which were prognostications at the time, have since come true. UI's earned ROE has been less than 5.6%. In fact, as Ms. Van Looney described, less than 4%, less than UI's current cost of debt. And also, UI is now making the request in the context of a general rate proceeding. However, despite those two things, there has not yet been any ruling on UI's request for interim rate relief, and accordingly, UI filed a motion in January of this year seeking response to our request, and there has not yet been one.
Thank you, Mr. Hurwitz. Subject to these updates, do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
I do.
Thank you. The panel is Thank you. The panel's available for cross-examination.
Thank you. Office of Consumer Counsel. No. NECTA. Attorney General. Thank you. Attorney Nigro. Thank you. Attorney Wyman. No questions for this panel. Thank you. Okay, we can move to page 4, which is our cost of capital panel. Request that the company's witnesses approach. All right, good morning, Attorney Vaughn.
Thank you. To the panel members, would each of you please state your full names and positions for the record?
Ann Bulkley. I'm a principal with the Brattle Group.
And Michael G. Panici, Vice President Treasurer.
Thank you. And if you have not been previously sworn, please raise your right hand. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you. Attorney Vaughn.
Thank you. Ms. Bulkley, as part of your preparation for this docket, did you provide pre-filed written direct and rebuttal testimony and exhibits, which were marked as exhibits UI AEB 1 through 12 and exhibits UI AEB rebuttal 1 through 16?
I did.
Did you also sponsor responses to interrogatories submitted in this proceeding?
I did.
Do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in an interrogatory response?
I have one.
Please explain.
On page 97 of my rebuttal testimony at line 12 through line 14, ending with the footnote 171, should be a question. And then the remainder of row 14 should be the beginning of the answer. There's a formatting issue there.
And thank you, Ms. Bulkley. And subject to that correction, do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
I do.
Thank you. Mr. Panici, did you also sponsor responses to interrogatories submitted in this proceeding?
Yes, I did.
Do you have any updates or corrections to your interrogatory responses not previously identified for the record in an interrogatory response?
I do not.
Thank you. And do you adopt your interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Thank you. The panel is available for cross-examination.
Thank you. Authority staff. Thank you. Attorney White. Attorney Wright. Thank you. Attorney Wilkerson, no questions. Attorney Nigro. Thank you. Attorney Wyman. Commissioner Conti, no questions. I do not have questions either. Thank you to this panel. This panel is excused. Which Dr. Woolridge is not yet available. Is that? Yes.
We just went to go get him.
You went to get him. Okay. We'll stand at ease until Dr. Woolridge arrives. Good morning, attorneys Wheel and White. If you can introduce your witness once he is settled, and I will swear him in.
Good morning. This is Dr. J. Randall Woolridge.
Thank you. Dr. Woolridge, if you could please raise your right hand, I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you, sir. Attorney Wheel.
Good morning, Dr. Woolridge. Did you file pre-filed testimony and accompanying exhibits in this proceeding?
I did.
Did you also file rebuttal testimony in this proceeding?
Yes.
And did you also sponsor any interrogatory responses in this proceeding? Do you have any updates or changes to any of those pre-filed exhibits?
No, I do not.
And do you adopt those pre-filed testimonies, exhibits, and interrogatory responses as part of your sworn testimony today?
I do.
And with that, the panel is ready for cross-examination.
Thank you. And first up, we have crossed by the company. So I'll turn to Attorney Venora, please.
Yes, thank you. Good morning, Dr.
morning.
Woolridge. How are you?
Okay.
Good to see
Nice
you.
to be back.
Yeah, not as quickly as we thought, but here we are. So, I'm going to start with your testimony. On page 9, you discuss capital market conditions. Do you see that discussion?
Yes.
As a general matter, do capital market conditions impact the return on equity that's required for an electric utility to attract capital?
Yes, I do.
Okay. And on page 4 of your rebuttal testimony, I'll give you a second. Sorry, I'm jumping around.
Oh, thank you.
Okay. Those.
Yes.
Okay. On page 4 of your rebuttal, you indicate that the Federal Reserve has begun the process of lowering the discount rate, which signals lower rates are forthcoming. Do you see that?
I have. Yes.
Okay. And do you rely on projected interest rates in your
No.
analysis? Okay. And your rebuttal was filed on March 2025. Is that right?
March 24th. Yes.
Okay. And is this statement that lower interest rates are forthcoming consistent with the current market conditions as we sit here in April 2025?
I think they do. There's several reasons. Obviously, the president and the Treasury Secretary would like to see lower rates. As it turns out, the Federal Reserve is expected to lower the discount rate by two times in 2025. So I think generally, obviously, given the uncertainty about some of the policies in Washington have created, in the end, interest rates are about where they were when I filed my testimony 2 months ago. And so it's pretty, they definitely financial market conditions affect the cost of equity capital.
Mhm.
And it's gone up and down, and obviously 2025 has been a little bit of an uncertain year.
Yeah. And do you believe President Trump's policies on tariffs are likely to lead to a higher rate of inflation?
I certainly think it's possible. The question is, I mean, the way these negotiations are going, I don't know if anybody really understands what's going on in terms of what his end goals are. That's right. Certainly there's a concern if he jams in, if he gets a lot of these through, there's a concern about inflation, but there's also, and so inflation kind of is going to kick up interest rates. On the other hand, the probability of recession will probably lower interest rates. So there is some dichotomy where rates are going up or down now.
Mhm. Are you familiar with the recent speech by Chairman Powell of the FOMC?
I'm sorry.
Are you familiar with recent remarks made by Chairman Powell of the FOMC?
I don't know exactly what remarks you're
Oh,
referring to.
okay. I'm going to pull them up on the screen if you give us one moment. These were the remarks dated April 16, 2025.
No, I mean, the specific remarks, I don't know all the details. I know that there's been uncertainty about kind of when they're going to start lowering rates again. And I think the Fed's concerned about potential for any inflation. So until they really see that inflation is going to back off, I don't think they're going to decrease rates. But they're expected to do it twice in 2025.
Okay. And is it your belief that President Trump's recent tariff policies are creating uncertainty in the capital markets?
I think it is. And I think I think it's getting resolved slowly. They're going to negotiate. I mean, he does things the way he does them. And certainly I think the Fed chief is really critical here in terms of maintaining an independent financial policy. And so I think it is. But I think his comments have been that, until we see some type of slowing of a potential inflation. Now, inflation was only 2.4% in March. I don't know what it's going to be in April, but certainly if the rates, if the tariffs go through, which we're still kind of watching this, I think the inflation, but also recession is another possibility, which has an opposite effect on interest rates. So I think every time you see discussion of inflation, you see a little higher rates, you see discussion of recession, you see lower rates.
Right. And so there is a lot of uncertainty right now.
I think, Bloomberg's written, they think there's a risk premium in the 10-year treasury, and it's because of Trump. So thinks the 10-year treasury is elevated because of the uncertainty in Washington.
Yeah. And are you confident that the growing market uncertainty will not create any increased risk for investors?
Well, I think it's creating uncertainty. You see it in the markets, but utilities have been great to hold this year. Utilities are up 3 or 4% in 2025. They've missed all the, S&P's down 7 or 8%, and they've had S&P's very volatile. Utilities have done well, and they see. I'm assuming that means that investors are looking at utilities. Yeah, there's a concern about higher rates or higher inflation, but the other thing is, it would seem that maybe a lot of this tariff stuff isn't going to impact utilities like it's going to affect other companies. So their stocks are up this year.
But didn't we start this whole discussion where I think we agreed that capital market conditions impact the return on equity that's needed for an electric utility? Isn't that right?
Oh, I agree. And what we're seeing is uncertainty over interest rates, inflation, that sort of thing. Some factors push it up, some factors push it down. Rates are about where they were when I filed my testimony. I think there is uncertainty, but again, utility stocks have been a good place to be. Not quite as good as gold, but they've done pretty well.
I want to talk about the CAPM for a moment. Just some foundational questions. Beta is used in the CAPM formula, correct?
That's right.
And beta is used to measure the relative risk of a company as compared with the market, correct?
That's correct.
Okay. And to estimate the equity risk premium for the company, you apply the beta for the proxy group in your calculation, correct?
Yes.
Okay. And you rely on companies in the proxy group to calculate beta so that beta is generally comparable to the subject company. We agree?
Yes.
Okay. And then you add the risk-free rate to that estimate in order to arrive at an ROE recommendation, correct?
Yes.
Okay. And as a result, the beta you are using in this analysis is the measure of the risk of the proxy group to the overall market, correct?
Yes.
Okay. So by definition, this gives you a beta to use as the measure of risk for the company as compared to the overall market. Is that right? Okay. And does this also mean that the proxy group you use in the CAPM needs to be reasonably comparable to the subject company?
Generally, yes, that's what you prefer.
Okay. And what would the beta of a group that is not comparable to your subject company tell you about the cost of equity for that subject company?
Generally, it says the lower the beta, the lower cost of equity capital. The market has a beta of 1 supposedly, and that means anything that has a beta greater than 1 is riskier than the stock market. Anything that has a beta less than 1 is less risky in the stock market. Utility betas historically have been about 0.7, 0.8. They're a little bit elevated now when they're measured on relative to certain indexes and that sort of thing. So like Value Line's betas are really inflated because they use the New York Stock Exchange index. And I explain that in my testimony.
But to my question about whether you're using a proxy group that's not comparable to the utility, your subject company, for example, if you relied on the beta for the tech sector, would that tell you anything about the cost of equity for an electric distribution company such as UI?
No.
Okay. What would options contracts for a group that is not comparable to your subject company tell you about the return expectations for that subject company?
I haven't used option prices, so I really don't know. I have no analysis that would give me an opinion one way or the other.
So based on your testimony, I assume that you would also recommend that the proxy group used to calculate beta should be consistent with the proxy group used to calculate the remainder of your cost of equity estimates, correct?
Generally, yeah, but I mean, we know the beta is going to be, I mean, the way I know Ms. Balke uses Value Line and Bloomberg betas, which are calculated differently. I use Cap IQ betas, which I adjust, and then I use Value Line betas. But I highlight my testimony some of the issues with Value Line betas. They use the wrong market index.
All right. I'm going to go to your testimony, and at page 56 of your testimony.
Yes.
Okay. And down at the bottom on line 19, you state there that you've relied on Value Line betas and S&P Capital IQ betas. Is that correct?
Yes.
Okay. And historically, you have relied on the Value Line betas, correct?
I have, but I explain in my testimony why I don't do that. It's because that the index they use is not, I mean, the average beta, okay, Value Line covers 1,700 companies. The average beta is 1.14. Well, in the CAPM, the average beta is 1.0. And I explain in my testimony why the beta is high. It's because they use the New York Stock Exchange index. You're eliminating the entire tech sector, which is more volatile in the overall market when you measure the market return. So they're elevated because of the way they calculate the market index they use.
Okay. And you testify across the country, correct?
Excuse me?
You, in your experience, you've testified across the country. Is that
Yes.
right? And it's fair to say you've testified for many years on cost of capital?
Yes.
And it's also fair to say that in your career as a cost of capital witness, the majority of witnesses, including those working for the company and for interveners, have relied on the Value Line betas?
They have. And again, I've looked into this and realized the problem with those betas is according to Capital Asset Parity Model, the beta mark is 1, and the average beta for the S&P for Value Line is not 1, and that's because of the market index.
Mm-hmm.
But you're right. I'm sorry. I have used them in the past. but I've come to say, and I look at S&P IQ, I look at Value Line, I look at Yahoo, there's big differences in the betas that they present. And it's about whether they're adjusted or not, whether they're measured using monthly or weekly returns or daily returns. So I explained that in my testimony that there's differences. I have used Value Line in the past, but I recognize there's some issues. So I also use Cap IQ, but there's probably 10 different sources of betas.
Okay. Have you ever relied upon a 6-month beta?
No, I don't think so. I don't believe so.
Okay. How about a 1-year or a 2-year beta?
No.
Okay. And as I think we just discussed in your testimony, you discussed the reasons why you're relying on 2 sources for beta, correct?
Exactly.
Okay. And both sources rely on historical data to calculate beta, correct?
That's correct.
Okay. And that means that the calculations performed by Value Line and S&P are using only actual observed data points to calculate beta based on the historical relationship between the company and the market. Would that be correct?
Again, can you please
Sorry to say it
restate
again.
that a little?
Sure,
It's
sure.
a little long.
Yeah, I know. I'll try to make that a little shorter. So given if the calculations performed by Value Line and S&P are using only actual observed data points to calculate beta, does this show that does this demonstrate the historical relationship between the company and the market?
No, I mean, I think, obviously, one of the criticisms beta, it's backward looking. You have to use actual market returns to estimate beta. And so it's backward looking, and, there is an adjustment that's done by many who adjust Value Line, Bloomberg, and others based on the historical relationship between historic betas and future betas.
Okay. But neither source that you cite to interpolates data points that do not exist or are unavailable, correct?
I'm sorry.
Neither of the sources that you rely on for beta interpolate data points that are not otherwise there based on actual.
Well, no, I mean, Value Line makes the adjustment. They use adjusted betas.
But if the data doesn't exist, do they?
Not that I know of.
Okay. If using option contracts to derive beta was a reliable method superior to the use of actual data to calculate beta, wouldn't Value Line and S&P be compelled to use that method?
I don't know. I mean, obviously, there's different ways of measuring beta. As I said, there's probably 10 different versions of beta available out there. I just haven't seen using options data. I haven't seen that used, but I'm not saying it's the ones I've seen have used historic data.
Okay. Considering the underlying data points used in an analysis, would you agree that the analysis is credible only if the data about the company and the market use actual observations?
Well, yeah, I mean, I believe you have to use actual data. I mean, it's available, it's observable in the marketplace.
If you did not have confidence in the individual daily, weekly, or monthly data points used to estimate the relationship between the market and the company, then you would not have any confidence in the relationship that is estimated using that data, correct?
Yeah, but I have no trouble with the data. At least I haven't discovered any.
Okay. One last question on this topic. In your experience, Dr. Woolridge, have you seen anywhere where a regulatory commission has specifically adopted or endorsed an option implied beta for purposes of the CAPM?
I don't know. I haven't seen it personally, but it could be someplace that I haven't seen, but I haven't seen any of it.
Right. In terms of your recommendation in this case, you're recommending a 9.375 ROE in this case, correct?
Correct.
And that recommendation is based on a 50-50 capital structure?
Yes.
Okay. You did not update your analysis in your SIR rebuttal testimony, correct?
I did not, again, there's been volatility, as I said, rates are about where they were when I filed it. Utilities have done well, their dividend yields have fallen off, because they've been a good place to be in this market of 2025.
Okay. And in your testimony, you based the ROE result on a range of model results that were from 8.8 to 9.95, correct?
Something like that, yes.
Okay. You recall that your DCF results were 9.65 to 9.95, correct?
Yes.
Okay. And your CAPM results were 8.8 for both the proxy group, your proxy group and Ms. Bulkley's
Yes.
proxy group. And you indicate in your testimony that you rely primarily on your DCF results?
That I have historically, and I used to rely much more. During the pandemic, DCF results were like 9% or so. CAPM results, which, because given where interest rates were like 5 or 6%. So during COVID years, I put almost all the weight on DCF, but I've always used both DCF and CAPM. I gave it much less weight during COVID. Now I give them more weight, but yes, in terms of my DCF results were a little higher than the CAPM results. The CAPM results are still pretty low, so kind of giving weight to those. And obviously, I explained the considerations and where I got the 9.375.
Okay. And the ultimate range you provided for the equity cost rate was 9.25 to 9.75?
Given that I had 8.8 to 9.95, eventually I said 9.25 to 9.975 was my range. I normally would put 9.5, but given that UI is less risky than the proxy companies, given that UI had, even my recommended capital structure of 50% is higher than the average of the proxy companies. And, UI's credit ratings, S&P of A minus, triple B, Moody's of triple B, they're better than the proxy group. So as a result, instead of 9.5, I'm at 9.375. And I see, they just announced today that the average authorized ROEs for electric distribution companies for the first quarter were 9.46%. So I'm a little below them, but not far.
So if the bottom end of your recommendation range is 9.25, that means you did give some weight to the CAPM, correct?
What I just said.
Right. And your analysis, this is based on data as of January 31, 2025?
Yes.
Okay. And the calculation of the CAPM is the risk-free rate plus beta times the market risk premium, correct?
Yes.
Okay. And the yield on the 30-year Treasury bond at the time of your initial testimony was 4.70%, correct?
4.7. It's about that today. It's right around there. 4.72, I think, this morning.
And at the time you filed your testimony, the average beta for the electric proxy group was 0.82.
But the way I calculate it, not the way, obviously, Ms. Bulkey uses Value Line and Bloomberg. I use Value Line and S&P Cap IQ.
Okay. And at the time you filed your testimony, you were using a market risk premium of 5%?
5, yes.
Okay. And therefore,
I look for market risk premium is the biggest mystery in finance, and you look at different measures. I look at what investment banks use, what JP Morgan, what I do a survey. I look at all the different market risk premiums used by investment firms. And obviously I put a lot in my testimony because I think the market risk premium is a big issue in this and all utility cases, because what investment firms are using is a lot different than what, say, some of the company witnesses have a much higher market risk premium. But Merton Miller, Noble economist, the biggest mystery in finance.
So Dr. Woolridge, I'm going to go to page 14 of your sir rebuttal testimony.
Oh.
We'll put it on the
Where,
screen.
where is it? I got it.
We'll put it
Sorry.
on the screen as well. And that, say,
Yes.
okay. And on that page, you state that the bottom line is that since authorized ROEs never declined as much as interest rates during the COVID years, they are now not increasing at the same pace as interest rates during the post-COVID years. Do you see that?
That's correct.
Okay. In your experience, do high interest rates tend to have a direct effect on utilities given the capital intensive nature of the business?
Certainly they do. And I think that's why you've seen utilities do really well in 2025. Kind of the expectation is interest rates are falling off and utility stocks have done well.
Okay.
I mean, I agree, yes. Obviously, if there's a big increase in interest rates, it's going to be detrimental to the utility sector. But what we've seen in 2025 is very positive.
Okay. In your experience, do investors become more conservative on utility stocks when they feel that utilities are experiencing economic conditions that make their operations more costly and more challenging to realize adequate earnings?
Well, I think obviously utility stocks are like all stocks. If, there's uncertainty, if their profitability falls off, that sort of thing, yeah, it's going to, I mean, that's true of all stocks, not just utilities.
Okay. Is it possible that regulators that are seeking to support utility investment would recognize that ROEs need to be maintained at a stable and reasonable level where interest rates are unusually low due to an anomalous event such as the COVID pandemic?
Well,
I'm going to object to that question. I don't see the relationship to Dr. Woolridge's testimony, and it sounds like it's asking for his opinion on what the legal standard regulators should apply.
Attorney Venora, a response?
I think it's directly relevant to his testimony. We're having a discussion about interest rates, the reasonable level of ROEs. Why don't I rephrase the question maybe to address that concern? Would the ROE, in order to support utility investment, would it be appropriate for the ROE to be maintained at a stable and reasonable level where interest rates are unusually low due to an anomalous event such as the COVID pandemic?
No, well, that depends on, I mean, in the end, that's what I show in my testimony, that's what happened. Interest rates fell to record lows. Now, authorized ROEs fell to record lows in 20 and 21, but they didn't fall nearly as much as interest rates. I have a study in my testimony to it. Now, I didn't have the data updated my testimony, but now that in like 2023, 24, as interest rates have gone up, interest rates have gone up like 100 basis points. ROEs have gone up 20 or 30 basis points. Why? They never declined with interest rates in 2021, just as a point made by the company's lawyer. And as it turns out, now that interest rates have gone up, they aren't increasing nearly as much as interest rates. I demonstrate that in my testimony. And the data for 2024 also supports it.
Okay. Going back to market risk premium, do you know what the market risk premium is that Kroll is currently recommending?
They just increased their market risk premium to 5.5%.
Okay.
I know. I look at a bunch of them. I know. You look at Fernandez. You look at Demoterin. You look at J.P. Morgan. I'm a big fan of Dr. Kelly at J.P. Morgan. He's like the Kim Kardashian of Wall Street. And when he lays out things, people listen to him. His annual capital market assumptions are a big publication, and it came out, and the numbers are low compared to other numbers.
And we agreed before, though, that the market has been increasingly volatile as a result of the recent U.S. tariff policies, right?
And that's why people, I think, are gone to utility stocks. Have done well.
And are the betas of your proxy group reflecting the higher market volatility since you filed the testimony?
Or can you please?
Yeah,
restate?
sure. I'll say, are the betas of your proxy group companies reflecting higher volatility since you last filed your testimony?
I haven't done any analysis like that. I just would assume that looking at what's going on with the S&P versus the S&P Utilities Index, clearly the utility stocks have been less volatile. But I haven't done any analysis to prove that.
Okay. Would you accept, subject to check, that since the time of your direct testimony, the market risk premium has increased and the beta for the proxy group has increased?
No, I mean, no, I mean, I've seen one measure of the market risk premium go up, and that's Kroll. The others have not yet. Normally, that means that at some point I will adjust mine based on what, JP Morgan's still down 4%, the motor is around 4%. So they're still, but I agree. I mean, Kroll did increase there due to the uncertainty. But at the same time, you look at Bloomberg, they say the risk-free rate's not risk-free anymore. There's a Washington risk premium on the risk-free rate.
Would you accept, subject to check, that if you updated your analysis for current market conditions, that your CAPM result would increase?
Well, I use the current risk-free rate, which is about 4.7. I haven't seen the betas, updated betas. The market risk premium, I haven't filed testimony recently where I've gone back, but I would look at Kroll, I'd look at the others, as I have in the past. Maybe I go to 525, just reflect what Kroll came out with. But again, I respond to what the market's doing. Okay, what's JP Morgan doing? What's, KPMG, they publish theirs. I mean, these are what investment firms use, and tell investors that this is what we're using.
So given that I think we said your testimony was based on data from January 2025, how much trouble would it be for you to provide an update to your analysis?
Oh, it'd take a week or two. But I think, one thing we've seen, utility stocks have done real well. Their dividend yields have gone down just because it's been a good market for utility stocks.
Yeah, I think I'd like to ask for a late filed exhibit for an updated analysis based on the current market conditions.
We'd object to it being a late file. I mean, the OCC doesn't have the burden in this proceeding. It's not our responsibility to continuously update the analysis. If the company wants to put on affirmative evidence that there should be some reason for an updated ROE analysis subsequent to Dr. Woolridge's filing, then that's the company's responsibility.
I'll withdraw. Dr. Woolridge, if reviewing your DCF results, again, you relied on the 30-day average stock price as of January 31, 2025, correct?
Yeah, I looked at 30, 90, and 180.
Okay. And for your electric proxy group, you calculated a growth rate at that time of 6.05%, correct?
Correct.
And that was based on the summary you provided in your exhibit JRW6?
Correct.
Okay, and you show there how you got to the 6.05, correct?
Yeah, I think that's actually JRW5, I believe. Yeah.
I'm sorry, yeah.
Page 6, JRW5.
Correct. Okay.
I mean, I give primary weight to analyst growth rate forecasts, recognizing historically they've been upward biased, and but I still give them primary weight. But I look at all projected growth rates that I have. Value line. I look at S&P Cap IQ as another growth rate forecast, that sort of thing. There are other forecasts, but some of them are the same source, like Zacks provides growth rates to other internet sites and that sort of thing, or And so historically, there's one or two sites that create or firms that create them, and then there are various internet sites like Yahoo that publish them.
Okay. And you did not update the DCF calculation in your rebuttal testimony, correct?
No.
Okay. Subject to check, if you did update it based on current data, would you agree the DCF result would be higher by at least 10 basis points than what you calculated in your direct testimony?
I haven't done that. I know the dividend yield would be less. The growth rates have been going up some. And so I haven't done it, but subject check, I would say it could go up 10 basis points. It could go down 10 basis points. I don't know.
How could it go down 10 basis point based on current market conditions?
Because the dividend yields of utilities have gone down because their stock prices have gone up. Stock market's gone down, utilities have gone up. And the other thing I said about my recommendation is obviously UI is a distribution or utility. You look at distribution ROEs, they tend to be lower than electric ROEs.
Okay, that's all I have. Thank you.
Thank you. Attorney Benor, just for clarity of the record, the documents that were being shown on the screen, were they exhibits or were they being offered for impeachment of the witness?
They were just for engagement of the witness. Mostly they were his testimony. I think there was one article, but we didn't really focus on it other than he was already familiar with it. So we weren't offering those for exhibits.
Thank you. I appreciate that. Authority staff have cross. Do you have cross? No. Thank you. Questions? I also do not have questions. Attorney Wheel, Attorney White, do you need a moment to consider redirect?
Sure, we just have 5 minutes, please.
Sure, we'll recess for 5 minutes.
It was the nature of it. Literally. It's actually. Yeah.
Dan is where to go. He shared better on the second. Anyway.
Okay, if we can come back together, go back on the record. Attorney Wheel, any redirect, please?
Yes, just a few brief questions.
Please.
Dr. Woolridge, is there only one way to calculate beta?
No, as I said before, there's different ways of calculating beta, and they're going to present somewhat different results. But yeah, there are different ways doing it using different time periods, different data sorts, different market indexes, that sort of thing.
Thank you. Does option contract data exist?
Yes, it does.
And is that data that is observable in the marketplace?
It's readily available too.
Okay. Last question. You considered authorized ROEs of other utility companies in your analysis. Is there some requirement that you must consider authorized ROEs in the development of the cost of equity for a utility company?
Yeah, no, I used authorized ROEs, especially looking at distribution and recognizing the fact that in the studies I cite in my testimony that authorized ROEs have been high relative to investor return requirements in the past. I highlighted a couple of studies in my testimony that have shown that. So yeah, I consider our authorized ROEs. Now, I think, for example, I mean, if I hadn't considered them, for example, during the pandemic, my recommendations would have been much lower because I would have just used pure market data and not considered authorized ROEs.
And would it have been inappropriate to do that for some reason?
No, I just thought, I mean, everybody, I mean, obviously Ms. Bulkey has an opinion on stuff. I have an opinion. All the witnesses are going to have different opinions and they're going to use different data and different approaches.
Thank you. That was my last question.
Thank you. Thank you, Dr. Woolridge. You're excused. We'll move to our next panel, which is a cost of capital panel with the EOE. If that witness and counsel could approach, please. Great. Good morning, Attorney Sahi. Attorney Lopez, would you like to introduce your witness, please?
Good morning, Chair Gillette, Commissioner Arconti. Mr. Rothschild, if you wouldn't mind stating your full name and position for the record.
My name is Aaron Rothschild. I'm president of Rothschild Financial Consulting. Yes.
Okay. Mr. Rothschild, if you could please raise your right hand. I will administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you. Attorney Sahi.
Thank you, Chair Gillette. Mr. Rothschild, as part of your work in this docket, did you provide pre-filed direct testimony, sir rebuttal testimony, and interrogatory responses in this docket?
I did.
And do you have any additions or corrections to your testimony or interrogatory responses today?
I do not.
And do you adopt all of these items as part of your sworn testimony in this proceeding?
I do.
And has anyone directed you to come to any specific conclusions here?
No.
Thank you. The witness is available for cross.
Thank you. We will turn first to cross-examination by the company attorney, Venora, please.
Thank you. Morning, Mr. Rothschild.
Good morning.
I'm going to start with some questions on your direct testimony. Page 40, chart 5. We'll pull it up, but I'll give you a moment to get there.
Yes, I'm there.
Right. In this chart, you show fixed weights for each proxy group. Is that correct?
Fixed weights for each of the companies in the proxy group?
Right.
Yes.
Okay. And where did those weights come from?
Where do the weights of the proxy groups come from?
Right. Yes.
I just made a calculation based on how many companies were in there and dividing them equally.
Okay. And the weights are not published anywhere in an established source. Is that correct?
No, but the results I'm getting for the S&P 500, if I remembered correctly, were almost identical to the public sources.
Okay. So you said you made a calculation to determine the weights, correct?
Very simple calculation is similar to arithmetic, yes.
Okay. It appears that you allocated $1,000 to each company as of July 1, 2024, and then divided that $1,000 by the company's share price to come up with the number of shares attributable to each company. Is that right?
Can you point me where you're referring?
It's my observation based on chart 5. That's what, we can also pull up your, let me pull up your spreadsheet.
Yeah, I'd like to see, just to make sure I
Sure.
know where you're referring.
It's taken a little time for your spreadsheets are large, so it's taken some time for that to load. Let me rephrase. Why don't you walk us through how you determine the rates? What was the calculation you used?
So I put for each of the companies in the proxy group, as I'd started by listing the stock prices I have forming from July 1st, 2024. So I have those various stock prices, and I built a portfolio where an investor invested $1,000 in each of those companies at that time. And then from there, I grew each of them based on the change in the stock price over time for each of them. So, and then I tracked what would be a portfolio of all those companies. Since there are 19 of them, it would be a portfolio of $19,000. And that's what that chart 5 shows is how that percentage changes over time.
And in doing this, you equally weighted each proxy group company as of July 1, 2024, correct?
That's right.
Okay. Do these companies have the same weights on December 31, 2024?
Do the companies have the same weights in July as in December 2024 as July 2024?
Yes.
Is that correct? Given that the stock prices have changed, the weightings would be slightly different, yeah.
Well, they would be different based on the relative move in the stock price, right? You said slightly. I don't know.
Yeah, each, you're talking about the weighting of the portfolio, the total portfolio. I think is what you're referring to. Because the value of the portfolio was $19,000 on July 1st. The value of the portfolio is $21,906 on December. And you're saying of that value of that portfolio, do the companies have a different percentage value on one date versus the other, is your question?
Right.
That's true.
Okay. Does the SPX index rebalance itself daily according to the market cap of each company within that index?
I would have to see, that's my understanding, yes.
Okay. But as you said, your equally weighted proxy group index does not reweight itself though, correct?
It's not market cap weighted, correct?
Okay. So as a result, you are comparing an equally weighted proxy group that does not rebalance itself during the comparison period to a market cap weighted index that rebalances itself daily, correct?
That is correct. I couldn't imagine it would make much of a difference over that period.
Isn't it true then that your weighting is artificial because it's not based on an established data source, nor any accepted method of weighting, and it doesn't have any correlation to changing market conditions?
I wouldn't agree. I would not agree with that at all.
All right, I'm going to switch topics. Mr. Rothschild, an options contract is an agreement between two parties to facilitate a potential transaction at some future date at a preset price. Would you agree with that?
Yes.
Okay. In executing an option contract, then the parties are agreeing to a forecasted price, correct?
They are agreeing, it's a contract, and a call option is the right to buy a stock at a certain price. A put is the right to sell a stock at a certain price.
Okay. A call or a put is viewed in the financial market essentially as a bet on the future price of an asset. Isn't that correct?
The term bet, where are you getting that?
That's my own term.
Your own?
My own characterization.
To the degree that you characterize it that way, the same would be true for the equity as well. If you buy the stock, it's a bet on the future stock price. Because if you buy the underlying stock, which the derivatives are the value is directly related to, you would also be betting that the stock is going to go up.
Would you agree that the call or put options are typically used like insurance policies or hedges against market trends?
Stock options are used for many reasons. They've become so broadly used in the market, particularly over the last 5 or 6 years, by institutional investors for various reasons, retail investors, and for many reasons. Some of them for hedging, others for a form of investing, like one would invest in equity as well.
So using them, among those uses though, would be a type of insurance or hedge. Is that what you said? That would be one of the types of uses.
There are many types of hedges. One type of hedging that can be used is with the use of options. It can also be just buying other kinds of securities that have different kinds of correlations as well. So I just want to make sure, yes, options can be used as hedging, but all kinds of different investments can be used for hedging in different ways as well.
Insurance policies are not generally relied on as establishing the true value of the insured property, though, are they?
You're equating options contracts as the same as insurance?
Yes. In my scenario, yes. Like, because I think you said one of the types of uses is for hedging.
I wouldn't agree with that characterization. That is just as an insurance policy.
If you wanted to know the value of an asset, why wouldn't the most accurate indication of value be actual recent transactions for that type of asset?
Well, if that was true for, I believe you're referring to stocks or equity right now?
I'm just talking about just asset valuation as a principle.
It depends on the situation, but I mean, I'm thinking of equity right now, stock prices, and you could say, well, the stock price is $100, for example. I mean, how would you go about assessing the expectations investors have for that stock price in the future? That's why I use options. They're extremely powerful. You can look and try to and be able to see what investors expect, various probability distributions of that stock price, that underlying stock price in the future. And again, these options are directly tied to the value of the underlying security. The power of them is we can see what those values are over different times, over different strike prices and various things. So it allows us to construct a probability distribution of that underlying. So if you just said the stock price, for example, is $100, there isn't as much you can do with that as when you have something like options that show a lot more information. I mean, if that was the case, that we could just use the price of the underlying, there would be no need to even look at cost of equity models or so forth. It doesn't, the price of the asset, we need more information to be able to measure something like the cost of equity or investors' expectations on that asset.
Did you read Ms. Bulkley's rebuttal testimony in this proceeding?
Yes.
Okay. And do you recall that Ms. Buckley's rebuttal testimony cites an article entitled, it's a Forbes article from September 2022. Do you recall that?
Yes.
And the article's entitled "The Put/Call Ratio Says Get in the Market Now." Do you recall that as the title?
I recall that.
Okay. Have you ever read that article?
Yes.
Okay. Did you recall that the article states, quote, "It is widely known that option traders, especially option buyers, are not the most successful traders. Option buyers lose about 90% of the time." Do you recall that from the article?
It's interesting because this article, it's talking about one thread of what's happening in the market right now. Stock options are used by major institutional investors. This is just one development that's been going on since COVID, where some retail investors are buying generally very short-term options like 0-day and so forth, where they're highly speculative and there has been a lot of loss. I don't use those options in my analysis, the 0-day and others that are short-term that have been used a lot. So I just have to make sure that's clear.
Okay. And do you recall whether in the article Forbes equated the option market to gambling? Do you recall that?
Again, from what I understand, this one slice of the market, I think they're referring to that there have been some investors, retail investors that could be characterized as gamblers.
Okay. In your testimony at page 53, lines 12 to 15, I'll give you a moment to get there.
I'm there.
Okay, and here your testimony refers to Warren Buffett as an investment guru. Is that correct?
53 line.
Lines between lines 12 to 15. It's on line 12.
Yes, I'm comfortable saying Warren Buffett is an investment guru. Yes.
Okay, so you would consider him an authority on stock investment based on that characterization?
In general, yes.
Okay. Have you read Mr. Buffett's 2023 letter to shareholders of Berkshire Hathaway, which was issued on February 24th, 2024?
I didn't read it. No.
Okay. On your direct testimony at page, I'm going to go to page 25, Mr. Rothschild. And specifically lines 12 through 14 on this page.
Yes.
Okay, here you state, I provide an expert interpretation of investors' return expectations as indicated by the current market prices of stocks, bonds, and stock options without attempting to predict future prices. Is that what you say there?
Yes.
Okay. So if we look next at page 36, your chart number 2.
Yes.
Okay. In this chart, this is a projection of where the secured overnight financing rate, SOFR, is expected to be as of September 2027, correct?
I would interpret this to be that the Federal Reserve Bank of Atlanta is going through the same type of exercise that I am in terms of calculating the cost of equity. They're using these contracts, including options contracts, to measure what investors expect this rate will be in the future.
Okay. But this is a projection, correct?
It's a measurement of investor expectations.
Which is a projection.
It's a measure of investors' expectations.
So if we go to page 38 and chart 3, this is a projection of inflation, correct?
Again, it's a measure of what investors expect inflation to be based on the TIPS market.
So with these two charts, these expectations, as you characterize them, how can your testimony be that there are zero projections in your analysis?
The key distinction is I'm not trying to predict the future. I'm not a stockbroker trying to sell stocks here or anything like that. I'm trying to say, what are investors expecting based on current market prices and interpreting what that means. Again, I'm not trying to pick stocks here or recommend stocks. So in that case, it's an important distinction. It's not my projection. These are based on expectations as measured by current market prices.
Okay. With respect to the calculation of beta in your CAPM, you use a 0.52 beta as your historical blend CAPM, is that correct?
Can you point into that?
This would be in your exhibit ALR4 at page 3.
I see in exhibit ALR4 page 1 for my weighted average historical blend is 0.52. Is that where?
Yeah, that's the one.
Okay.
So on this exhibit, do you have it in front of you? Because it's on the screen too, but maybe a little bit small.
So you're referring to Exhibit ALR 4, page 3 now?
Right.
Yes, I have that in front.
Okay. And so this appears to be the average of your historical blend beta, which was calculated weekly between October and December 2024. Is that correct?
That's right.
Okay. And there you have 14 historical blend betas that you calculated, and then you average those, correct?
I average them based on the weightings that are put below.
Right, right. And to calculate each individual week's historical blended beta, you weighted the 6-month beta by 50%, the 2-year beta by 25%, and the 5-year beta by 10%. Is that right?
Yes.
And where did those weights come from?
I think I explained that in my direct testimony. I'd like to refer to that. I explain on page 73 of my direct testimony, starting on line 9, and I explain why do you use periods of 6 months, 2 years, and 5 years for your historical beta calculations, as opposed to relying exclusively on 5-year periods used by Value Line. I say using shorter periods for the return regression analysis portion of the historical beta calculation allows me to see if the correlation between the returns of each of the companies in the RFC Electric Proxy Group and those of the S&P 500 index has changed in the last 2 years or 6 months. Using a 5-year period exclusively tends to make recent changes in the correlation more difficult to identify because of the weight of 5 years of data. Does that answer your question?
I was going to re-ask it. I think it does, but so my original question was, where did those weights come from? And I take it from your answer, you describe in your testimony how you made it, you basically are proposing those on your own, correct?
Yes, I don't want to waste people's time looking through the testimony. I believe I explained this and I can find it, but I'll just explain it. I mean, there is no necessarily perfect weighting. I mean, we could debate what they would be, but I would say 100% weighting, which of a 5-year, which is often used by witnesses, or they may use the Value Line 5-year 100% weighting, and then also a weighting of a 10-year, say, Value Line beta. They make that choice as well, and I disagree with that strongly. As I explained, I think it's worth considering the developments of the 6-month and 2-year. Should I weight them a little heavier, a little lighter? You could be open for debate, but I think the choice to do 100% weighting of the 5-year is usually less accurate in terms of measuring the current cost of equity. In particular, I mean, as I had predicted, the 5-year historical betas for utility companies are coming down now. I mean, why? Because they're finally, the data that was impacting them back during COVID is now leaving the data. I mean, for years, these 5-year historical betas were very obviously upwardly biased because they were being impacted by the turmoil that was caused during COVID. And so weighting them as 100%, I think, is upwardly biased, or has been in recent years.
Is there any authoritative source that you can cite us to that averages betas using those weights?
I think I had explained my reasoning. I mean, it could be. I have not seen anyone. I would be surprised if someone used that exact same weighting that I had done.
So the answer would be no to my question.
I'm not aware of any, but I would be surprised. Every analyst has to make various decisions. The idea that you would be able to find exactly what you're doing. I mean, I would. Is there any for any witness? There are decisions that have to be made, and I explained the reasoning behind it.
Is there any investor or institution that you can cite us to that weights betas in those proportions?
I'm going to object. I think he's already answered that question. It's been asked and answered multiple times, I think.
May I respond? No, that hasn't been asked and answered. I asked him if he had an authoritative source. I'm now asking if he's aware of any investor or institution that uses the same weightings that he does.
Okay, I'm going to overrule the objection.
Thank you.
The witness can answer, please.
In terms of knowing what investors use, I believe is really unknowable in terms of investors that I've spoken to, the various kinds of strategies with using, whether they're betas or other kinds of strategies, are almost as diverse as people. So the idea that you could go and find someone that has the exact same weighting, I don't even know how it would be known. I mean, most trading is done, it's proprietary or done on the fly. I mean, I remember hearing of a study where they went to go see in London what, in terms of the capital asset pricing model, what were investors using, and they found that everyone had their own little adjustment of the various traders. So I think this idea that I think is implying is that there would be one or two or three or a certain amount of methods that are used is just, from my experience, not correct.
So the bottom line really is that the weights are just your own work product that you've made up, correct?
I explained the reasoning behind it. Characterizing it as made up, I think, is not true. There was a reasoning behind it.
All right. Mr. Rothschild, I'm going to go to page 72 of your testimony.
I'm there.
Okay, lines 14 through 16 of your testimony. And on these lines, you state the following: studies have found that betas calculated based on investor expectations, parens option implied, close parens, provide information regarding future perceived risks and expectations. Do you see that?
Yes.
What studies are you referring to there?
I'm referring to the paper here, which is the option implied measures of equity risk by Bo-Yang Chang and Peter Christofferson and Chris Jacobs. That's footnote 76. That's one of them, and also some of my own investigations.
Okay, so when you use studies in the plural, the only study other than your own would be this article that you cite?
Yes, by the research that were done by these scholars, not just this paper, they have some others as well, but yes.
Okay. Mr. Rothschild, I'm just pulling up a copy of the article. Can you just, this is part of one of your filings. Can you confirm this is the article that you were referring to?
Yes, subject to check. That does look like the article.
Okay. And in calculating your option implied betas, you use option contracts that expire in 6 months or 180 days into the future. Is that correct? You say that on page 78, line 18 of your testimony.
Sorry, what page number again?
You're on your page 78, line 18. My question was, in calculating your option implied betas, you use option contracts that expire in 6 months or 180 days in the future, correct?
Yeah, but it's also important in my rebuttal testimony. I also show the option implied betas, or the option implied growth term structure. So for the betas here, is 6 months, but I also show the term structure for what is indicated by investors' expectations over longer time periods on chart 2 on page 20 of my rebuttal testimony.
Okay. But in your testimony where you cite to this paper, I'm going to pull up at page 421 of that paper. Do you recall in this article that you've cited as your source, it says the following: the main focus in this paper has been on forecasting 180-day ex post betas, which are relevant for certain applications such as abnormal returns. For other applications, such as cost of capital calculations, longer horizon betas may be needed. Do you recall it saying that?
I do, and it's important to, this was a paper written in 2011. They talked about future research that was needed. We have looked intensely into this question, as we had spoken about, in particular during COVID, when historical betas jumped up during that initial turmoil in the markets. The option implied betas within a few months fell. And then all of the historical beta calculations fell in line like a waterfall. It was almost, in terms of the type of result that you could possibly get from capital markets, we're just almost surprised at just how much this showed that the historical betas fell in line with the option implied betas. They were clearly a lead in terms of measuring what historical betas were going to be. So to the degree the capital asset pricing model is something that's worth doing and that historical betas mean something about risk, I've shown definitively, and this is data that's way beyond this paper since it was published, because we have so much more option data to use when compared to when this paper was published, we can see clearly that option implied betas are a forward measure of what historical betas will be in the future. And this paper, I would certainly love to speak with the authors about this.
Yeah.
Yeah.
But a minute ago, this is the only third-party source that you've cited for your proposition in your testimony, correct?
These are the authors that developed this. And then
And this source says it actually does not validate the use of the 180 days for cost of capital calculation, correct?
yeah, I have definitively shown that it is applicable. This is not,
I'm asking you about, sorry, go ahead.
This has been an area that I've worked on for decades, and I believe it's my role to take research like this and see to what degree it applies here. If they saw this result, I would be surprised if they wouldn't agree that I've definitively proven that it is a measure, that 6-month option implied betas are a powerful measure of the cost of equity. And we can look to authorities, and I think that's good to start here. There's all kinds of various, even the research that they have here is built up on a lot of research in the areas of interpolation and in various areas that are critical to finance. But obviously this is moving, and we've taken and definitively proven it is applicable.
But the one source you do cite does not validate your use of the 180 days for cost of capital calculations, correct?
I'm going to object again. I think we've gone through this colloquy and he's already answered this question numerous times.
I think I've only asked it one other time, and I don't think he answered it directly.
Okay, I will ask Attorney Venora to restate the question one more time.
Okay.
And Mr. Rothschild, you can answer.
Okay. In the one source you cite in your testimony, this source actually does not validate the use of the 180 days for cost of capital calculations, correct?
This study that was done, an excellent study that was done in 2011, using the data that they had at that time, came to that conclusion. Since that time, we have a lot more options data that's exploded. We can show definitively that it does.
The option contracts for the S&P 500 index look forward 5 years, don't they?
They go out to, I think now they're out to even 6 years.
Okay. Do you publish your betas online?
We've shared the betas in many different presentations, but we don't. So in that sense, we have shared it. You're saying, oh, do we publish them regularly online? Is that what you, no, we don't at this time.
Are you aware of any online source that has developed betas like yours?
I have not done an exhaustive search. Again, from what I've seen, the amount of different kinds of modeling techniques or various data that's used by investors is so vast and wide, it's impossible to even know. I think that's just very important. Just look at something like Thinkorswim on Charles Schwab alone. The amount of and the variety of types of data that's provided is massive. I just want to make that point. It would be impossible to do a complete search and see all the variety of thousands of different models. I mean, literally even probably millions that are used by various investors. So I just don't know.
Is there anywhere online I could go to look up your betas?
I'm not aware of where you could go to look up, calculate it exactly as I have. But you could go to many different places, and I could point to where you can see option implied measures. The Federal Reserve Bank of Minneapolis, the Federal Reserve Bank of Atlanta, we could go on.
And would those be done by under the exact method as you?
No, but it's important to know that the underlying pieces that I built are based on identical methodologies developed by the Chicago Board of Options Exchange. And that you can see online, the VIX index and skew index and so forth.
In Ms. Bulkley's rebuttal testimony, she includes an exhibit, UI AEB rebuttal-9. Do you recall that exhibit?
Let me find it. Could you put it up on the screen?
Yeah, that's it right there. Okay, does this look familiar? I'm sorry, I'll give you a minute.
That shows the growth rates for each of the companies? You just make it a little bigger, yeah, thank you.
Yes.
Option implied growth rates for the 19 companies in the proxy group. Yes, I recall seeing that.
Okay. And are you aware that this is based on your work papers where you provide the data, 3-month data from October to December 2024 that was used to calculate your betas? Do you recall that?
Yes.
Okay. In looking at this exhibit, is it correct that you didn't have any data for 4 of your proxy group companies, specifically Alliant, LNT, Avista, AVA, Northwestern Corporation, NWE, and OGE Energy, OGE?
Yes, 4 of the companies in the proxy group I didn't calculate any option implied growth rates because they didn't have options that met the strict criteria I have for filtering, the same one that the CBOE uses. Yes.
Okay. And in this chart, you see the red letters N/A.
Yes.
And those NAs mean that there's missing data, correct?
That means they didn't make the filtering criteria, so I did not include them. It wouldn't, yes.
Okay. And therefore, you only had data for 68% of your proxy group, correct?
For 15 out of the 19 companies, I had data.
Okay. Can you show me in your testimony where you explain how you've controlled for the fact that you only had data for 68% of your proxy group?
I think we always have to deal with the data that we have. I think that's true for any analyst. And this is why you can see the data, and you can see, I show which data is included and which is not. And so 15 of the 19, I think that represents a fairly large percentage of the companies in that group and is representative.
But in fact, there's nowhere that you revealed that point in your testimony, is there? It's
Revealed here in the work papers that can be seen. I can't reveal every aspect of the data, and that's one of them that's there. It can be seen in the work papers.
You don't think it's material to disclose that you failed to have actual data for this substantial portion of your proxy group?
I think it's certainly reasonable to ask me about this, and that's why I provide all the data.
That's all we have. Thank you.
Thank you. If I could ask the OCC to begin their cross, we'll go about 20, 30 minutes before we break for lunch. Thank you.
Morning, Mr. Rothschild.
Good morning.
My computer is fully charged, but if I didn't bring this charger up here, it would die in the next 15 minutes, I'm sure. So, my name's Tom Wheel. I am from the Office of Consumer Counsel, and we've met before, right?
Yes.
Okay. I'm going to start with some questions about your testimony. With respect to capital structure. On page 10 of your testimony, you talk about the relationship between the authorized equity ratio and risk. As I understand it, you discuss how a higher common equity ratio presents a lower chance of financial risk. Can you explain why that is?
Yeah, so a higher common equity ratio means you have less debt, less leverage, right? Because higher percentage of equity, less percentage of debt. So the reason why in general is that you have, as a general percentage of the income you bring in, you have a lower percentage to service the debt. So generally speaking, you're going to have the capacity to handle a greater fluctuation of earnings over time. So you'd be able to handle any changes. So that's why a higher common equity ratio, lower leverage, leads to lower financial risk.
Is it kind of similar in concept? Like when I go to apply for a mortgage, if I refinance my house, if I have a higher level of equity in my house, I can maybe get a better rate on that refinancing than if I had less equity in my house?
Yes, I think that would be related, certainly, yeah.
Thanks. You also reference a regression analysis, and you reference that there should be a 4 basis point reduction in ROE for every 100 basis point increase in the common equity ratio. And I saw you provided that analysis in response to EOE 6. And I got to tell you, I tried to understand what that was, but I could not. Could you explain in simple terms what that analysis is showing and why?
Yes, I did that analysis a long time ago. It was much easier to do at the time in the 1990s because there wasn't, most of the companies that were traded, we didn't have as many of the holding companies with, that had also unregulated operations. So it was easier. You could get a more pure look at at how capital structure and the cost of equity are related. So what I looked at was a group of utility companies, and I calculated a cost of equity for each of the companies based on a discounted cash flow. And then I looked at ran a regression of their capital structure, so looking at their common equity ratio. And I saw that the DCF indicated cost of equity was related to the capital structure, and in that way that led to the number that you referred.
Okay. Thank you. On page 13 of your testimony, you say that the spread between A-rated corporate bonds and triple B-rated bonds is currently around 33 basis points. So I guess that's the first question, just without a mechanical terms, does that suggest that a company with an A credit rating is likely to be able to issue debt as at a 33 basis point lower rate than a company with a triple B rating?
Yes, in general, you have the way the Federal Reserve Bank of St. Louis does that. They have a various portfolios of bonds and do various calculations. But yes, that's what it means. That generally speaking, when a company that issues has a triple B bond rating is going to have to pay about 33 basis points more for their debt than a company with an A-rated bond rating.
Thanks. And does that Federal Reserve Bank of St. Louis resource show the spread among other credit? I'll back up a little. There are a number of different credit ratings and two primary credit rating agencies that use slightly different rating labels. Is that correct?
Yes.
And does that resource for the Federal Reserve Bank of St. Louis indicate the spreads beyond just from A to triple B?
Yes, they have a number of them. Yeah.
Did you provide that resource with your testimony or anywhere else in the record?
In terms of spreads between other bond ratings?
Yeah, just what you were looking at the Federal Reserve of St. Louis to what you were referencing for that 33 basis point spread in your testimony.
I believe I provided a site where the Federal Reserve Bank of St. Louis, where they provide that information for all kinds of different spreads, like for example, the triple B and triple A, double A, and so forth. I believe I cited that, but I don't think I provided here the spread between triple A and double A, for example.
Would it be possible to, the company actually issued you an interrogatory, which is the UI EOE 3, that asked you for all cited works in your testimony. Would it be possible to supplement that response with a showing of the most recent corporate bond yields for all investment grade bond ratings?
Yes.
From the Federal Reserve of St. Louis?
Yes, I could do that.
Okay, I'd like to enter that as late file exhibit. So I'll enter it as late file exhibit number 2 and describe it as a supplement to EOE 3, UI EOE 3.
Thank you, Chairman. But I do want to ask you some more questions about the 33 basis point spread itself, acknowledging that that spread might be different. Well, I'll back up. Is it possible that if you updated that information that there might be a slightly different spread based on more updated debt market data?
Yes, it changes all the time. Yeah.
Okay. So acknowledging that 33 number might change with that supplement, I do just want to ask you some sort of conceptual questions about it.
Mm-hmm.
So, and I think I'm going to ask you to do a little basic math, maybe. So hopefully you have like a calculator, or you're probably able to just do this in your head. If an A-rated company could issue debt at, say, 4.5%, 4.5%, does that mean that a triple B rated company in the same market could expect to issue debt at 4.88%? That's 33 basis.
So I was thinking, the 4.5% was for what rated? A rated for 4.5, yeah.
And so a triple B then could expect a 4.88% rate then?
Based on that data at that time, yeah.
Okay. And that increase to debt cost, would that apply to all of the company's existing liabilities? Or would it only apply to new debt issuances subsequent to the debt rate increase?
Yes, yeah, good question. It would only apply to the new bonds that were issued. For example, if a utility had issued bonds at a much lower rate during 2021, they wouldn't be impacted if they still had another 10 years before they matured. They wouldn't be impacted.
Right. So if a utility issued a bond at 4.5% as an A-rated company, and then there was a downgrade to triple B, that 4.5% bond would have no impact unless it was refinanced. Is that correct?
Yeah, for the company, in terms of the cost, they would still be paying the interest rate based on the 4.5%. Yeah.
Okay. And when you recommend a cost of debt for the purposes of setting rates like you did in this proceeding, do you use a company's actual average cost of debt?
Yeah, that's the focus, unless there's an extreme situation or some, which rarely happens. Yeah, generally, that's just a mathematical exercise of looking at the bonds that are outstanding. Yeah.
Okay. So for instance, in this proceeding, you recommended a long-term cost of debt at 4.93%. And on page 103 of your testimony, you noted that that was UI's requested cost of long-term debt. Is that correct?
That's right.
Okay. Have you looked at Schedule D at all in the company's original application?
It's been a while. I think. Yeah.
Would it be possible for you to open up Schedule D-3? Might take a while to get there.
Schedule D-3. I can look. Is that something you can put up, or
Unfortunately, I'm not that prepared.
Let's see. Yeah. Okay, I have it in front of me now.
Thank you. And are you looking at an Excel spreadsheet or a PDF?
Excel spreadsheet.
That's good. Okay. So if you look at cell N42 of that spreadsheet, do you see that 4.93% there? Sorry, I think I
Yes.
did. Okay.
That's right. I see it.
And what's your understanding of how that figure was calculated in that cell?
My understanding, can look again, but when I remember going through this, was that it's based on a calculation of the interest rates for all of the outstanding bonds at that time. And it looked at the annual interest rate for each of the bonds and including the notes, and looked at the total, basically, in essence, the total value of the bonds, and you're able to see that the rate was 4.93%. the book value of the bonds.
Okay. So that 4.93% is using data from all the bonds that are shown on that spreadsheet?
Yes, I don't believe it's missing any, but
All right. And I counted like 19 debt instruments on that spreadsheet. Is that your understanding of what the spreadsheet shows?
yeah, it goes from, yeah, looks like 19. Oh, wait, 17. Oh, there's some up top, 50. Yeah, they're not, including the notes below, I believe, yeah.
Okay. So the reason I was asking about this is I was a little confused by a piece of your testimony. So I'm going to go back to what we were just talking about the 33 basis point example. On page 13 of your testimony, starting on line 16, you say, however, in the interest of providing a very conservative analysis, even if UI was downgraded and it resulted in a 33 basis point increase to the cost of debt, this increase would still be very modest compared to the cost savings from a lower authorized ROE.
Hmm.
So just thinking about this mechanically, like I want to just talk through that hypothetical. If UI was downgraded and its cost of debt increased 33%, wouldn't that require that UI issue all new debt or finance its entire debt package in order for that to happen?
That's a great question. That's another level of conservatism to really my analysis. That's absolutely true. It would not kick in right away.
Okay. So conceptually, if UI were downgraded and its cost of debt increased 33 basis points, and then it immediately issued a bond, would that bond presumably be additive to the 19 bonds we just looked at on that schedule?
Yeah, so it could, if this 33 basis points, it would, depending on the size, it would have an impact, but it would depend how large the bond is. It may have a quite small impact on the overall cost of debt. Yeah.
Okay. So in your testimony, when you talk about the hypothetical that UI could incur a credit downgrade and it could increase its cost of debt by 33%.
33 basis points.
Thank you, yes. 33 basis points. The actual impact on the cost of debt as calculated for rate-making purposes would likely be lower than 33 basis points, right?
Yeah, certainly in the short run, it might take 10 or 20 years to fully work its way out if it stayed that spread stayed there for that long. Yeah.
Okay, thank you.
Attorney Wheel, if you wrap up with this hypothetical, we'll take the break.
Sure. Actually, I have a couple more questions about the concept. I think that maybe right now would be a better time to take the break.
Take the break right now.
I'm just not sure I'm going to get through the concept in like the 4 minutes before 12:30.
Understood. Okay, let's break. We will reconvene at 1:15.
Yeah. Thank you.
Yeah, exactly. Probably see emails you came back. Yes. Yeah. They're gonna switch things around. Well, that's good. Yeah, you know. Or like. Oh, yeah. Look. Yeah. But this morning. Yeah, that's why I was like. So. Yeah. Thank you, and thanks for all your help. Oh, yeah, of course. Pocket panels. That's, I was gonna say, I think, a little longer than that, yeah, I was thinking. Yes, I don't mind.
Okay, and go back, Attorney Venor? No.
Thank you, Robin. Thank you. I just had a quick administrative matter before Attorney Will got back into his cross-examination. During my cross-examination of Dr. Woolridge, I had started to ask for a late filed exhibit. I'd like to renew that request for a late filed exhibit, which was for the witness, OCC witness Woolridge to provide an update to his CAPM and DCF results based on current market data. During Attorney Wheel's cross-examination of witness Rothschild, he's asked the witness for an update to the evaluation. I think it is appropriate in this circumstance because Dr. Woolridge equivocated on whether the update would show his numbers to go up or down. And so we simply request the right to, we request that he provide that update for the record to give us an opportunity to review and evaluate his updated information.
Thank you, Attorney Whale. Do you renew your objection or?
Yeah, we renew our objection. Just again, the OCC doesn't have the burden here. We have a budget for our consultants in these cases, and the budgets are. We've had to, as the authority and other parties are probably aware, we've had to move to expand the authorized level that we've already spent on consultants in this case. Dr. Woolridge's proposal to us in response to our RFP did not anticipate having to redo his entire analysis again midstream. For all those reasons, we would renew our objection.
Okay. Okay. Let me just take a brief recess and give the authority 2 minutes.
Can I just, okay, that's fine. I was just going to say, I was just going to respond briefly to
I'm sorry, I can't hear you.
I was just going to respond briefly to Attorney Wheel. I don't think this is a matter of I know the company has the burden, but when the OCC puts a witness on, I think there is a responsibility for the witness to have to answer questions on cross, and also his analysis is dated. It's based on data from January, and there's been some significant market changes since that time. So that's the reason for the request.
And with the authority's allowance, I would just respond. I think the company can argue that in its brief. I think it can make whatever it wants of the lack of an updated analysis from OCC, but I don't think the company can, as a legal matter, sort of force us to provide an updated analysis at ratepayer cost.
Thank you. All right, we'll take a brief recess, please. Okay, we'll go back on the record. I am going to sustain the objection from the Office of Consumer Counsel and direct the company, to the extent that you wish to address this issue, to do so by speaking to it in your brief regarding the weight of the evidence that you think the authority should afford. So if there is nothing further before we begin cross, Attorney Wheel.
Thank you. Mr. Rothschild, before the lunch break, we were discussing the potential impact of different credit ratings on the cost of debt. Do you recall that conversation? Okay. So I wanted to go back to your testimony for a minute. On page 91 of your testimony, you discuss the comparison between that referenced 33 basis point difference between an A rating and a triple B, I think it was, and the 200 basis point delta between your recommended cost of equity and the company's requested cost of equity. Do you recognize that part of your testimony?
Yes, I do.
Okay. You say that the reduction in the cost of equity would be more than 6 times the this conservative estimate. I think you're referencing the 33 basis point increase to the cost of debt there, right?
Yes, comparing the 200 basis point spread between our ROE recommendations and the 33 basis points, yes.
Okay. And it says here that you're assuming a 50-50 capital structure for that.
Yeah, that's correct.
Okay. So I just wanted to flesh that out a little. When a company has a 50-50 capital structure, meaning 50% equity and 50% debt, the weighted cost of both debt and equity is 50% of its non-weighted cost. Is that correct?
Yes.
Okay. So like a 33 basis point increase to the cost of debt would impose a 16.5 basis point increase to the weighted average cost of debt if in a 50-50 capital structure?
Before accounting for the tax impact, yeah.
Okay. And again, pre-tax, a 200 basis point decrease to the cost of equity would impose a 100 basis point decrease to the weighted average cost of capital, and also in a 50-50 capital structure. Is that right?
That's right.
Okay. And the weighted average cost of capital, is it your understanding that that has an impact on the company's authorized revenue requirement?
Yes.
Okay. And is it your understanding that you take the weighted average cost, that when Pura sets the ultimate revenue requirement, that it's inclusive of a calculation of taking the weighted average cost of capital and multiplying it times the authorized rate base?
Yes, that's right. Again, you have to gross up for taxes on the equity portion, yes.
Okay. So if the company's requested rate base is about $1.4 billion, a 100 basis point decrease to the weighted average cost of capital would be worth about $14 million. Is that correct? For pre-tax.
Yeah, that sounds right. Yeah.
Okay. And would a 33 basis point increase to the cost of debt be worth about $4.62 million? Again, it would be a 33 basis point increase to the cost of debt, imposing a 16.5 basis point increase against a $1.4 billion rate base.
Yep.
Okay. So when you talk about the relative difference between a cost of debt increase of 33 basis points and an equity cost, a cost of debt increase of 33 basis points and an equity cost decrease of 100 basis points, if you plugged in all those numbers, again, pre-tax, would it be, that's the kind of comparison you were talking about there, like the difference between $14 million down and $4.62 million up?
Yeah, exactly. And again, like you had pointed out, this is conservative for 2 reasons. One, it would take time, even if the 33 basis points was the right measure, it would take time for that to affect rates, because you'd have to be implementing the debt at the higher rate. But also, as I explained, wouldn't necessarily be 33 basis points increase at all.
Okay. But the company's proposed capital structure in this case isn't 50-50, is that correct?
That's right. It's higher. Yeah.
Okay. Is it
Higher common equity ratio. Yeah.
Yeah, is it 54% equity and 46% debt, the proposed capital structure?
That sounds correct. Yes, 54% common equity. Yep.
Okay. So to calculate the weighted cost of equity in a capital structure with a 54% equity ratio, you would multiply the cost of equity times not 50%, but 54%. Is that correct?
That's right.
Okay. So in the company's proposed capital structure, the decrease in cost of equity of a 200 basis point decrease would impose an even bigger rate decrease as compared to the increase of cost of debt. Is that correct?
That's correct.
Thank you. And just for the record, sorry to make you do math again, but a 200 basis point decrease in the cost of equity would impose a 108 basis point decrease in the weighted average cost of capital, right? Given a 54% equity ratio.
Yep.
Okay. And a 46% debt ratio would mean that a 33 basis point increase to the cost of debt would impose a 15 basis point increase to the cost of debt. Is that correct?
I'd agree. Subject to check on that.
Okay. So as we discussed prior to the break, as well as we just discussed, there are reasons that 33 basis point increase, the 33 basis point increase comparison you reference in your testimony is conservative for several reasons. Is that correct?
Yes.
Okay. And you referenced this before, but I was going to get to it, so I wasn't ignoring you. But the cost of equity imposes income tax expense on a utility as well. Isn't that correct?
That's right.
Okay. So is it your understanding that when PURA sets the revenue requirement, in this case, they use the imputed cost of equity, in other words, the cost of equity that is set for rates as a basis to determine the expected income taxes that are also built into rates?
Yes.
Okay. And given that they're built into rates, those income taxes are also recovered from ratepayers. Is that correct?
That's true.
Okay. So if the authority were weighing a potential increase, I'll back up a little. Does the increase, does debt impose any income tax burden on a company?
No.
Okay. So if you increase the cost of debt, there is no incremental increase to the cost of income tax. But if you increase the cost of equity, there's also an increase to the cost of income tax, correct?
That's correct.
Okay. So if the authority is evaluating a scenario where there's a potential increase in the cost of debt caused by a potential decrease in the cost of equity, do you think it's appropriate to take that into account as well?
Yes, you should take the tax effect into account. Yeah.
Thank you. I wanted to move on to some more general questions about what the purpose of your testimony is, kind of broadly, like what the purpose of what you're trying to accomplish in determining the cost of capital for United Illuminating. On page 88 of your testimony, you say that UI's authorized ROE should always be set at a level that allows it to raise capital on reasonable terms. And on page 28, you say that an authorized ROE of 8.43% would be, quote, sufficient for a regulated utility like UI to raise capital from investors. As a basic concept, is it called, we're talking about the return on equity, but the phrase cost of equity is often used interchangeably with that term. Is that correct?
Yeah, so the purpose of my testimony is to recommend or to determine the cost of equity for United Illuminating based on capital market data. And then that, of course, is what gets then applied, would get applied if adopted as the authorized ROE. Yeah.
Okay. So is it called the cost of equity because it's essentially the cost that ratepayers have to pay a utility in exchange for the utility's capacity to raise equity capital?
Yes, that's true. That's what I'm trying to measure, the very cost or the return as represented by the return investors require to provide the money. Yes.
And I think you talk about this in your testimony, but is it similarly conceptually to the cost of debt in that when you pay interest on debt, that's essentially the cost you have to pay in order to access debt capital?
Yes.
So the earnings that a company collects from ratepayers, is that conceptually similar, meaning that's the cost of accessing equity capital?
Yeah, it's the same. It's just that it's harder to determine that for equity, but it's the same concept. We can see the bond yield when they issue it, so it's easier. But with the equity, as you know, we have to use the cost of equity models, but the concept is the same.
Okay. On page 53 of your testimony, you say a computation of what the market indicates investors require to provide I have an ellipsis in here, required to provide capital to companies with comparable risk to UI. That's how you describe your analysis, correct?
This is on page 53.
Yes.
I want to make sure I'm looking at.
It's page 53, line 1, so the very first line.
Yeah, that's right.
Thank you. So again, the purpose of determining the cost of capital is to determine what investors, both debt and equity investors individually, but together, require in order for the utility to attract equity or debt capital. Is that correct?
That's correct.
Okay. Are you aware of utility models that don't need to raise equity capital because they finance their investments entirely with debt, like a municipal utility, for example?
I've seen all kinds of different scenarios with certain smaller utilities where there are all kinds of different situations, but it's usually just because they haven't kept up. I'm not sure with municipals, but I have, and with investor owned, I have seen situations where it's all debt. For investor owned, it's very rare, almost never.
If a utility were to finance all of its cash flow entirely with debt, would there be a need to attract equity capital from investors?
If they raised with all debt, I don't think that would, I guess I can speak to that if you want, but you're just asking for the mathematics of it. I mean, it would be a simple fact. If they raised everything with debt, they would not be raising any equity. That doesn't mean they should do it that way. Yeah.
Okay. But here, because UI is an investor-owned utility, it is able to finance its investments with equity capital. Is that correct?
Yes.
Okay. Do you have an opinion on the benefit of a utility having access to equity capital? I guess whether there is a benefit, and if so, what the benefit is.
I guess you're asking to compare, like a municipal type model versus investor owned? Kind of.
Yeah, I guess the question is just, is there a benefit to a utility being able to access equity capital as opposed to financing all of its investments with debt?
Well, I guess I'll say from one perspective, just from financial perspective, a company that raised everything with debt would be, reckless. They'd be in big trouble if they had all debt because they could easily go bankrupt. I don't even know if they could raise it all, or the cost of debt would be extremely high. It would not be wise to do that at all. But certainly, so the benefit of being able to offer to raise equity, I think the way that I see it is in terms of the benefits of having an investor-owned utility. And certainly, the arguments are that the investor-owned utility has the incentive to keep costs down and to serve their customers. So I think if the degree that we're saying the investor-owned model is the investor-owned utility model is the best one, then that's really the benefit, being able to tap into equity markets was really the benefit of that. Yeah.
Okay. Do you think the cost of equity capital should be commensurate to the benefit of accessing equity capital?
I guess I have to say, I feel like it's a little bit maybe beyond the scope here because I'm just trying to really look at capital markets and talk about what investors require based on capital market data, really. So I'm not, at least the way I'm interpreting this is going, an interesting conversation about the different, maybe differences between a municipal model versus investor owned. So I just haven't gone there in this testimony. Yeah.
Thanks. Well, and the reason I ask is that, we at OCC often find ourselves in a position, especially lately, frankly, where we are asked, what am I paying for? Asked by ratepayers, why should I be paying this? And why should I be paying this much for this? So I guess the question is, should the cost of equity be set in consideration of the value of the equity capital that a utility is raising in exchange for the contribution that ratepayers are providing?
I guess from my scope of my testimony, I really just look at what it costs, and I think that within this model, it would not be good for anyone if the authorized ROE was set below the market-based cost of equity. But my main objective is just to say, what are capital market data saying about that?
Thank you. In your understanding, how does United Illuminating raise equity capital from investors?
They do not raise it directly. Before and they don't raise it directly. Then, is my understanding, they haven't, at least for a very long time.
And by not raising it directly, what do you mean by that?
It's raised through their parent company. They're going to raise the money, the equity capital. Yeah.
Okay, so the parent company owns United Illuminating. Is that your understanding?
Yes.
Entirely?
Yes.
Is the parent company the investor from whom United Illuminating seeks to attract equity capital then?
I guess you could put it that way, but ultimately where the parent would raise it, whether when they were publicly traded, in terms of looking out into the markets. So depending how you want to define it, but yes, they need equity capital. They can get it from the parent, and then where that's ultimately raised, of course, would be another question.
I ask because, all the witnesses in this case and every other rate case, as far as I know, are evaluating the interests, the appetite, I guess you could say, of equity investors on publicly traded markets.
Mm-hmm.
But there's a disconnect, right, between what those investors are evaluating. I guess I'll back up. Those investors are evaluating the potential financial performance of parent companies of operating utilities. Is that correct?
We're trying to, we have to use publicly traded companies because that's where the data is, and it's not a perfect fit. I mean, a lot of those companies have riskier, unregulated operations that are impacting it. So it's not a perfect fit, but it's really the best that we can do. So that's why we use it. So I think that's what you're kind of going. Is there a little bit of a mismatch there? And yeah, I think there is. I would view it as somewhat conservative then, because we're looking at these at the holding company level where the stock is publicly traded, and it's not always a perfect fit.
Yeah, thanks. I did see that in your testimony that there's a discussion, I think, in there, as well as I think the other testimonies in this case about publicly traded parent companies being sort of, I think that's why they maybe called a proxy group, right? Is that it's a proxy for the interest of investors in this particular company. But I guess my question was whether what we should be thinking about in terms of United Illuminating's ability to access equity capital is whether its parent company is willing to provide equity capital, as opposed to whether the market is willing to provide equity, invest in the equity of its parent company.
Again, I think my scope is I look to the investors, I look to the capital markets, really. So that's where I go. I know I mean, that's kind of I've heard that in many different jurisdictions as a kind of a threat. They say like, we may not want to invest here in this state if your authorized ROE is lower than our other authorized ROEs in other states. That is obviously, as I've explained a lot in my testimony, that kind of comparison is wrong to do. It's not the right comparison. If the market-based cost of equity, for example, for a company is 8%, and they have an authorized ROEs that are higher than that, they're going to invest. If they have an authorized ROE that's in that range of 8%, they're going to want to invest, even if some other jurisdictions have even higher ones. So I think that can be frustrating when it kind of becomes a type of threat or the wrong basis of comparison by saying, we're only going to invest in jurisdictions that have higher ROEs is wrong. We have to look to the capital markets. And it's very clear my recommended cost of equity here is 8.49%.
Okay. Thank you. And just quickly for clarification, when you say you've seen that in other jurisdictions and what you described as a threat, are you describing a situation where a parent company that owns several operating companies in other states, in more than one state, says that because they receive a higher authorized ROE in a state where one of their subsidiaries is in, that they're going to prioritize investment in that state? Is that what you're referencing?
Yeah, they might say, for example, we have an authorized ROE of 9% in Kentucky. Why would we invest in 8% in Tennessee? And that comparison is not valid.
Okay. Thank you. On page 52 of your testimony, you referenced the HOPE standard. I think you quoted there saying the return to the equity owner should be commensurate with returns on investments in other enterprises having corresponding risks. Do you see that?
I do.
Okay. And like we discussed a couple of minutes ago, the purpose of your analysis is to determine the level of return for investors to provide capital to companies with comparable risk to UI. Is that correct?
Yes.
Okay. Could you do that by just awarding UI the same ROE as other regulatory commissions award other utility companies?
No, it's very dangerous, as I explained. I mean, if for no other reason other than we can't possibly update. It's looking around at what has been done in other jurisdictions or in the past. What happens if capital markets change? I mean, we're talking here about capital markets changing. They have to be evaluated over time. So that's looking back. That's one problem. The other is there isn't any type of potential error correction. What is everyone else doing? Could we as a herd then be running in the wrong direction? I think it could be dangerous.
And on page 26 of your testimony, you discuss how your analysis doesn't include a recommendation to look at ROEs authorized in other proceedings. Is that correct?
Yes, I write a lot about that concept I think my main point there is just, well, I'd explained already the dangers of doing that. So that should not be the basis for setting an authorized ROE, is looking around for the reasons I explained.
Okay. And on that same page 26, there's a quote from Alfred Kahn, not Alfred, noting that utility stocks trading above book value reflect a recognition that utilities are, quote, being permitted to earn considerably more than their cost of capital. And specifically, the discrepancy between market and book value demonstrates that, quote, commissions have been allowing returns in excess of the market cost of equity. Do you see that?
Yes.
So what does that mean? Like, what is the book value of the stock as compared to the cost of capital have to do with other commissions awarding of ROE?
Well, it's the authorized ROEs are applied to the rate base. So of course, the portion of the rate base that's funded by equity is going to be pretty similar to the book value of equity. So when you have an authorized return basically applied to book value, when investors are willing to pay a premium of book value, that means that the cost of equity generally is lower, right? And that would just, I mean, I've spoken about that so many times with people, and I think it is somewhat intuitive, but sometimes it's not. I'll just give one, quick example because I think it's helpful. It's just kind of a real estate example. I mean, if someone goes out and you build a building for $1 million and your rent is let's say $10,000 a month, so you're bringing in 12% on a year. If the market value doubles, so it becomes a $2 million building, just the simple math is you're not going to be earning 12% anymore. The new market cost, that indicates it's gone down because that's if the rent stays the same, it's 120,000 divided by 2 million, and that's 6%. So to just say that that's irrelevant is really kind of ignoring, I think, some simple math. I'm not saying you could just do that. You have to look a little deeper in terms of growth and so forth. But I mean, we've been seeing these market to book ratios significantly higher. So I think Alfred Kahn's discussion there is right on target. This is really a highlight that those authorized ROEs are too high.
In your experience and knowledge, is a market to book ratio a relevant metric for equity investors generally, like outside the context of utility company investment?
It can be, but it's particularly relevant in terms of regulated utilities because of the way regulation works, applying the authorized rate of return to rate base, which is very close to book value. So that's why it's particularly relevant in this case.
Okay. So in your opinion, do investors who are looking at utility stocks pay attention to the market to book ratio?
Yeah, I don't know how they wouldn't consider that. At least you never know exactly what all investors are considering, but of course it just mathematically it's something that's very relevant. Yeah.
When you look at, if I were to look at like Yahoo Finance to pull up a company, if you've looked at Yahoo Finance or similar kind of publicly available information about the performance of a particular stock, you can see lots of metrics on there are kind of commonly measured metrics. Is that right?
Yes.
Is market to book ratio commonly among the various metrics that are evaluated on those kinds of websites?
Yes.
Thank you. When we're evaluating the authorized ROE of other companies, is that a measurement of the expectations of investors or the subjective determinations of other regulatory commissions?
Well, when you say expectations, the main point is it's not a measure of the expectations of the return investors expect to receive, because an investor looked at the authorized return on equity, they can see the market to book ratio. If they do the math, they're almost certainly expecting to actually earn a return when they look at their dividends and how much they're going to sell the stock in the future, that they're going to earn less than that. Does that answer your question? Yeah.
Yes.
Okay.
Given your experience in testifying before various commissions around the country and general knowledge about utility regulation, is it your opinion that ROEs authorized by other regulatory commissions accurately reflect the market cost of equity capital?
I think in general, I think Dr. Woolwich had cited one of the studies that have come out recently that really have showed that there's been data that they have been excessive for a long time. I'm not going to get into why or anything like that, but just when I look objectively at what my numbers are saying in capital markets, I think they've been excessive for a considerable amount of time. I think you'd have to go back maybe to I was not testifying, but I think if you go back into like the 70s and 80s, there was a time when that might have not been the case then. I think market to book ratios are about 1, or even went a little lower than 1 for a while, and that was problematic. But it's been that long since that was the case.
Thank you. I was literally about to ask you about Dr. Woolridge's rebuttal testimony, and I was going to ask whether you had seen figure 2 on page 17, and we're actually putting that up on the screen in a second. Have you seen that figure?
Yes.
Was that what you were referencing just now when you discussed Dr. Woolridge's the study in Dr. Woolridge's rebuttal?
I believe so. There's a number of different ones. Let me look. Yeah, that's really the summary of that one study that I had in the back of my mind as I was saying that. Yes.
Okay. And can you tell me your understanding of what this chart is measuring?
But it really shows that as interest rates had declined over that period from the 1980s, that authorized ROEs did not follow. They seem to be quite sticky. So that's one of the indicators that they have remained potentially did not fall in line with the changing cost of capital.
Okay. So are the like, as I understand it, correct me if I'm wrong, and I know this isn't your chart, but the multiple lines down there are showing interest rates using different kinds of interest rate measurements. Is that correct?
Yeah, I can see it has the corporate bond yields
Okay.
and treasuries as well. Yep.
And the speckles that they're circular and triangle kind of black marks are showing authorized ROE. Is that your understanding?
That's right. That's my understanding.
Okay. The reason I ask is that you were just speaking a minute ago about how, although you weren't testifying at that time, I was also not testifying, but I was in, elementary school. But in the 1980s, you made a reference to authorized ROEs being closer to the cost of capital. Is that what we're seeing on this chart here, the kind of clustering of all those black marks with all the kind of peaking lines?
Yeah, it's interesting. I wasn't thinking about that chart in this case. I was thinking about the market to book ratios, but this is another potential indicator that those were in line at the time. We had higher interest rates, higher authorized ROEs, and the market to book ratios were closer to 1.
Okay. So does this, I asked you a moment ago about your experience and understanding of the authorized ROEs of other regulatory commissions as they relate to the actual cost of capital. Do you think that this chart is a good representation of the relationship between those two things?
I think it's helpful. I don't want to get the cost of debt and the cost of equity are often pretty highly related. This wouldn't be the only information to review, but it is one piece that's quite revealing.
Thank you. I want to ask some questions about volatility. Beginning on page 43 of your testimony, you talk about the volatility of stock prices. I have some kind of fundamental questions about that. So like pretty much any market, the prices of equity markets fluctuate. Is that correct?
Yes.
So like if I were to buy a stock for $25 today, I might not reasonably expect that it would still be worth $25 next week or tomorrow, or maybe even 5 minutes from now, depending on how volatile that stock is. Is that an accurate statement?
Yeah, I think it would be a little reckless or unfortunate if you were buying stocks and didn't think it could change. Yeah.
Okay. But is that the general concept of volatility, like the measurement of volatility is how much a stock is likely to change?
Well, you could talk about volatility from a historical sense, how much has it changed? And then you could talk about the expectation for change. Yeah, one is, the common way to look at that is option implied volatility, which is the VIX index, also known as the fear gauge, and that's what it does. It measures the option implied volatility, and that can go up and down, and that's why I use it to calculate the cost of equity as part of it, because it's a very important measure.
Thanks. And as I understand it, volatility of the stock market matters to equity investors because it has a direct bearing on their perceived risks of capital gains or capital losses. Is that an accurate statement?
Yeah, I think absolutely. If they see if they have higher expected volatility, that's higher uncertainty. That generally correlates with higher levels of risk. It's not perfect. Also, why I account for skewness, which is also, and that's why we get into the whole option implied betas, because it might be that the expectations in terms of the skewness, where in terms of for stocks going, in terms of how far they could go up or down or skewed in one direction, how that relates to the overall market leads to our concept of betas, and that's important. But yes, I mean, you really start with that concept of expected volatility, and that higher volatility, all else equal, leads to higher risk and higher cost of equity.
Thanks. I am at the baseline starting, I'm at the high school level here. So, but thank you for going through with me. So just to kind of chew through that a little bit more, like if I have a strong reason to believe that that stock I buy at $25 will be worth $30 at some future point, my comfort in buying that stock is going to correspond with the strength of that belief. Is that an accurate reflection of the idea of how investors see volatility?
You're talking about from like the perspective of an individual investor.
Sure.
Yeah. Yeah. I mean, if an investor is going to buy a stock for $25 and they feel very strongly it's going to be $30 the next day, and that would be very attractive. Yeah.
Okay. And if I think there's a chance that $25 stock might be worth $100 at some future point, but also could be worth $5 at some future point, are those beliefs going to change the dynamics of the attractiveness of that stock to me?
Oh yeah, absolutely. Yeah.
Okay. So the less I am as an investor, the less an investor is sure about, or, no one can ever be sure, right? Like no one can see the future. But the less sure an investor is, would reflect a higher level of expected volatility, and the higher the potential reward would need to be in order for that investor to invest. Is that correct?
I think, as I understand what your question is, if there's a higher level of uncertainty in terms of a greater span of possible outcomes, that's generally investors would demand a higher return. And you also talked about, I think, which is kind of related to maybe the idea of a skewness too, because they might feel, well, there's a chance that this stock could go down to $5, generally much higher risk stocks like, say, a biotech firm would generally see that, then that gets taken into consideration as well. So not just the span, like the fan, but also how skewed it is. And that's an important part that I've been looking at for a long time, is option implied skewness, is what the CBOE does as well as a skew index, because it's a measure of kind of like what investors expect the chance of a very large drop. And you can see for utility companies, generally that's lower than for the overall market. So that's just another dimension to the kind of the probability distribution that investors see. And they see a chance of a large drop is less than for the overall market.
And skewness, you referenced the structure of volatility, right? And that's about like how much the volatility itself will be volatile, will change over time. Is that correct?
The skewness?
Yes.
It's really I would say more of the shape of the distribution. So you might have, like, say, in an extreme case of some very risky biotech firm, you might actually have the probability distribution might have a big peak that's way down, like it's going to go to 0 if this doesn't work, or if it works, it's going to go to 1,000. So it just looks very different than another company, which may be more like kind of like a normal distribution, where it's most likely going to go up or down by 1%, and then the chance of it going way up or down is very low. So that's really what I mean by when you consider the skewness.
Thanks. You have a chart on page 46 of your initial testimony that, as I understand it, shows how the market responded to COVID-19 and the Ukraine war.
Yes.
And as I look at that chart, is it showing that there was a general expectation of high volatility that would decrease over time? Is that what that's showing?
Yeah, exactly. That shows the whole, what's called the term structure of volatility. So it showed when you looked out at the 1 month time frame, which is generally what people look at, the VIX index, it was extremely high. And then, but investors expected that to go down over time. So that the volatility expectations of the 24-month timeframe were quite a bit lower, still elevated from today considerably, but still you had a downward sloping term structure.
And the comparison to today on this chart, that's like the yellow line, the yellow line here is measuring the expectations as of December of the close of 2024.
Yes, that's right. They're very different shapes. So now it's a slightly upward sloping. I mean, it's relative to what was going on in COVID, it was like going down a ski slope. And this one is flat. But if you look closer today, the term structure is slightly upward sloping. It's a kind of a gently increasing cross-country ski trail. Yeah.
Okay. I'm not sure, I think there was some discussion about it this morning, but I'm not sure if you've read the news lately, but there seems to be some volatility again in global markets recently, more recent than December of 2024. Is that correct?
Yes.
Can you discuss how markets have reacted to the international trade tariffs that have been imposed or threatened in recent months?
Well, the big development, as Dr. Wolbers was mentioning, is utility stocks have done extremely well, including electric utility stocks. I don't have the data in front of me now, but I think at one point the spread was 15% different in terms of the market being down 12%, and electric utilities being up 6, 8, 10%. So it was a pretty strong divergence where regulated utility companies have been overperforming the overall market, and it started around mid-February.
As you've been reviewing option data, is there a similar trend? In other words, what Dr. Woolwich was discussing, I think, is the actual performance, the recent historical performance of the utility industry as opposed to the overall market. Are option investors also seeing utilities as a safer or as compared to the overall market as a more attractive investment?
It's a little more mixed, I find, when I go beyond the performance of the stock. So when you look at historical betas for electric utilities, they've been coming down a little bit. So it's like the 6-month, 1 year, 2 year, 3 year timeframe. Even the 5 year has come down a bit. But the options have been a bit flat, even slightly up, I would say. So it's kind of, in terms of in the DCF world, and that's why we tend to like to look at different worlds. In the discounted cash flow world, it's starting to really potentially look like a declining cost of equity. And I would say in the CAPM world, from what I've seen, very preliminary, it's probably pretty flat in terms of, I think, about the same through this. So I think that's the both kind of support, which really makes sense that investors find utilities relatively attractive. It's kind of maybe a classic case of a flight to safety, some bonds into utility stocks.
Thank you. I had some questions kind of related again, going back to the idea of the relationship between like a parent company and an operating company. Your testimony notes that your proxy group is made up of publicly traded electric utility companies, and that it's, like we talked about before, necessary to use those as proxies because UI itself is not publicly traded. Are your proxy companies all publicly traded on the New York Stock Exchange?
I believe they all are, yes.
Okay. Are you aware that United Illuminating is a subsidiary of Avangrid?
Yes.
Are you aware that Avangrid's no longer traded on the New York Stock Exchange?
Yes, I'm aware.
And that Avangrid is now a wholly owned subsidiary of Iberdrola?
Yes.
And Iberdrola is publicly traded, but not on the New York Stock Exchange. Is that correct?
That's my understanding, yeah.
Okay. I was just curious, because Iberdrola is traded on international markets, whether you think it would make sense to evaluate investor expectations on those markets, or if there would be any difference in your opinion if one were to evaluate the international markets on which Iberdrola is traded?
My first thought is that wouldn't be necessary because what we're really trying to do our best to estimate what is the cost of capital to fund United Illuminating really on a standalone basis, operating here in Connecticut. So if there's some wrinkles about why raising money in foreign markets impacts the cost of capital, certainly United Illuminating's consumers shouldn't pay for that. There's no reason, unless I could see the argument. But to answer your question, I don't see any reason to do that, and certainly United Illuminating's customers shouldn't pay for any higher cost of capital if that was caused by raising money internationally.
Thank you. Just one moment. Just a couple of quick questions about your rebuttal testimony. On page 1, starting at line 13, you discuss this question about whether investors require a higher return on capital to invest in Connecticut. And there's some testimony here about some data from observing the market yield on Connecticut light and power bonds.
Yes.
Can you discuss what that data shows and what the bearing is on the suggestion that there's a higher cost of capital in Connecticut?
Well, there's been a lot of talk about credit impacts of credit rating agency statements about Connecticut and how it's impacted various things. So it's certainly interesting to read, but it's good to go to look at what investors are saying in the market. So if these debt investors thought Connecticut really was kind of riskier than the companies in, say, our proxy group that we're measuring, you should expect to see higher market yields on the bonds trading in the secondary market for CL&P versus the companies in the proxy group. But I didn't find that at all when I looked at the secondary market. In fact, as I show on the chart 1 on page 3 of my rebuttal testimony, the bond yields for CL&P are a bit lower than on average for the companies in the proxy group, and also lower than the market yield for Eversource Energy, so at the holding company level as well. So that is a powerful indication of what investors think about Connecticut and the relative risks. Now, that is the debt market. As we were explaining on the chart you were showing there before, we often look at debt markets and the cost of debt and how they may relate to the cost of equity, and they can be related, but sometimes not perfectly one-to-one, and that's why it was also interesting to look at the acquisition premium for Aquarian, another step, and the acquisition was for $2.4 billion, which is 1.7 times the overall rate base, which again indicates we're seeing that market-to-book ratio coming through into the sale as well, which is another indication that investors are certainly the cost of capital, and in particular the cost of equity, isn't really any higher in Connecticut.
Thank you. So just to be clear, so I was going to ask, this chart 1 on page 3 shows, as you mentioned, both Eversource, the parent company, and Connecticut Light and Power's bond yields. And at least recently, since dating back to 2023, on average, it appears that the Connecticut Light and Power bond yields have been lower than Eversource. Is that
That's
correct?
right, yeah.
And that's true up until this data stops in February of this year, 2025?
That's right.
So is the relevance of that Eversource owns subsidiaries outside of Connecticut?
Yes, but I don't know what, did they also own some wind farms or other things that are unrelated? I know that the credit rating reports are mentioning that in terms of some of the issues with things that have certainly nothing to do with Connecticut. So yes, there are other, whether it's other jurisdictions, but I think particularly, which would be the red flag, would be some of these other investments that are outside rate of return regulated utilities.
Okay. We did notice that at OCC in the credit reports. So is the suggestion here that comparing the bond yields of Connecticut Light and Power to Eversource, that isolating Connecticut Light and Power is a better reflection of the debt market's view of Connecticut than looking just at Eversource would be a indication of the debt market's view of Connecticut?
Yeah, it was a nice way to target in more on Connecticut. Yes.
Okay. And you mentioned the sale of Aquarian at being 1.7 over book. And that what that means is that your understanding is that the proposal is that someone is willing to buy the Aquarian Water Company for 1.7 times the value of its rate base. Is that correct?
Yes, it was 1.7 times the value of its rate base.
Okay.
So we'd have to go through the exercise we were saying before, what 50-50 capital structure, whatnot, to figure out a market to book ratio on the equity. Yeah.
Okay. But generally, what's your understanding of like as compared to any other utility company acquisitions you might be aware of? How does a 1.7 times return on an acquisition compare? Is it lower, higher, in line with other acquisitions you've seen?
Actually, I don't have another premium acquisition, but I do, one of the relevant benchmarks would be the market to book ratios of the companies in my proxy group. And they're at, as of December 31st, they're at about 1.78, 1.79. So it's pretty similar to the 1.7 figure here.
Okay. So does that, and I apologize, I'm sure all my questions are like, they seem really obvious to you, but does that indicate that equity investors in the company in your proxy group are expecting a somewhat similar level of return as the investors in the proposed Aquarian acquisition are?
Yeah, it certainly indicates that, expecting, or say requiring. It doesn't, these data, this fixed income investor data and this acquisition data is indicating that, which is, yeah, that's what the data is saying. Yeah.
Okay. And again, this might seem like a really basic question, but is the fact that an investor is interested in purchasing a utility in Connecticut for 1.7 times book indicative that there is interest in utility investment in Connecticut?
Yeah, it certainly is a data point for that. Someone's willing to put $2.4 billion into Connecticut so that so someone wants to sell, if there's a buyer on the other end, someone who's willing to come in and put the money. I think it's just a fact there.
Thank you. The last thing I wanted to ask about is also on page 2 of your surrebuttal. You note, it says this real-time market evidence aligns with S&P Global's 2025 industry credit outlook, which described Connecticut's regulatory construct as credit supportive. Do you see that?
Yes.
What does that mean for S&P Global to describe Connecticut's regulatory construct as credit supportive?
I found it interesting because when you read through those reports, it's all kinds of things that are stated all over the place. But in the end, it seems to be this, when they come to this bottom line, a fixed income investor says, oh, it's credit supportive. You could say all kinds of details, but it's credit supportive. And then do investors believe that statement? Well, the market yields seem to say yes. That's how they see it, consistent with that statement, given that market yield on CLNP's bonds are even lower than the proxy group and lower than its parent.
Thanks. And do you know if credit supportive has like what's your understanding of what that means? Is that like a rating? Like would S&P describe a different regulatory environment as is it your understanding there are kind of different ways to describe different regulatory environments from S&P's perspective other than credit supportive?
I believe yes, I haven't seen, I haven't done, I can't speak to that. I don't know what, for example, they've said about, say, Pacific Gas and Electric and bankruptcy with their credit negative. I suspect so, but yes, they have a range of other outlooks, and for there it was well, you heard what it said. So I'm not sure the whole distribution of their of what they've said for other utilities.
Thanks. Yeah, I was just asking, you mentioned a phrase credit negative. So I was just asking really basically whether it's possible to rate, I guess I'll back up, like we talked earlier in our discussion about credit ratings generally, that there's A, triple B, there's various kind of grades that agencies assign. Is credit supportive? I recognize it's not a credit grade, but is there a similar kind of construct where S&P can refer to a particular regulatory environment as, for example, credit negative?
Yeah, again, I haven't seen that specifically, but yes, that would be a little surprising. I mean, I don't know why they would say it's credit supportive, but watch out, don't invest here. I don't. I mean, I guess they could say that, but it would be nonsensical.
Okay. I think that's our last question for this panel. Thank you.
Okay, thank you.
Thank you. Authority staff? No questions? Okay, thank you. Do not have any questions either. Director Lopez, Attorney Sahi, do you need a moment to consider redirect?
Just one moment.
Okay, do you want to recess or?
I don't think we need to recess. It'll just take a moment.
Okay.
We do not have any redirect. Thank you.
Thank you, Mr. Rothschild, you're excused. Okay, if I can ask the Attorney Venor.
Thank you, Chair. I wanted to, in light of the OCC's cross-examination of Mr. Rothschild, he's offered some new information that goes beyond the scope of his initially filed testimony. And in light of the fact that the company has the burden of proof in this case, I'd like the opportunity to bring back the company's cost of capital panel to respond to some of the testimony that Mr. Rothschild has just provided.
Okay, one moment, please. Attorney Venor, can you summarize the scope of issues, please?
Sure. There was the questions relating to current market conditions, market volatility, parent and subsidiary relationships, and how those various considerations factor into the determination of the cost of equity. In what was, I guess I'd characterize Attorney Wheels Cross as friendly cross-examination that elicited some additional information that Mr. Rothschild did not put in either his direct testimony or his rebuttal testimony, or I'm sorry, his surrebuttal testimony. So the company has not had an opportunity until now to hear that testimony. So we are asking for an opportunity to bring the cost of capital panel back. I think that this request is consistent with PURA's regulations, 16-1-39, which gives a petitioner in a case like this the opportunity to open and close on each portion of the matter, being the ROE topic.
Okay, thank you, Attorney Venora. And so the request is for the company to conduct a limited direct or limited.
It would be limited, yes, it would be limited direct, I get in response only to the new information. And then the company's witnesses would be open to cross-examination on the additional testimony that they would provide.
Okay, thank you. And I couldn't write fast enough, so if you could just tell me I think you named 3 or 4 topics that you wanted to.
Yeah, I mean, I was just going by the broad topics of Attorney Wheels Cross, but it would be capital market conditions, market volatility, parent and subsidiary relationships, cost and factoring into the cost of equity calculation.
Okay, then I will grant the company's request and ask the cost of capital witness for the company to reapproach. I'll allow the limited redirect on, I think that was 3 or 4 topics that you just.
Yeah, and our, Ms. Bulkley reminds me also on Connecticut regulation is also a factor in relation to credit ratings.
Okay.
Okay, thank you. Commissioners, thank you very much. We appreciate it. Ms. Bulkley, figure 2 in Dr. Woolridge's testimony, did you hear Mr. Rothschild testify that this chart demonstrates that the market to book ratio was equal to 1?
I did.
Is it possible to determine that from this chart?
No, it's not. This is, just to be clear, this is figure 2 in Dr. Woolridge's surrebuttal testimony. This is a plot of authorized ROEs and bond yields. This does not have market to book ratios on the chart at all, nor can you derive it from this chart. What you can determine from this chart, however, is that it's very consistent with the bond yield risk premium analysis that I prepared in my direct testimony, and it demonstrates the inverse relationship between interest rates and the risk premium. And if you were to look at my direct testimony at exhibit UI AEB 8, In that analysis, we have prepared a statistical analysis as compared to just the graphical representation of this data. And that statistical analysis demonstrates the inverse relationship and also does the calculation to determine at the current interest rates, what would the returns be? And in that exhibit, my analysis demonstrates using the plotted data and the regression analysis as opposed to just a chart of the data, that the ROEs would be in the range of 10.24% to 10.41% based on the interest rates at that time.
And Mr. Rothschild discussed the term structure of volatility and how there was greater volatility around the Ukraine war, but that 24 months out, there is an expectation that the volatility would be reduced. Do you agree with that?
No, I don't. One of the issues there that Mr. Rothschild failed to acknowledge is that oftentimes the 24 months out, there's not enough liquidity in the data to be able to draw any meaningful conclusions. You actually have to have enough trades to be able to demonstrate any kind of a relationship further out. But oftentimes, beyond the 6 to 9 month range, the volume of trades has declined significantly, and it's inconclusive.
Mr. Rothschild testified that utility stock prices have been up 8 to 10% this year. Is that true?
No, that's also not true. If you were to look at 1 month prior to the tariffs that have been imposed by this administration, the S&P 500 was down approximately 4%, and utility stocks were up about 1.6%. This year, the utility stocks have not been up 8 to 10%. That's just simply false.
In his testimony, Mr. Rothschild suggests that the multiple in the transaction for the Aquarion Water Company is indicative of the fact that the Connecticut regulatory jurisdiction is positive. Do you agree with that?
I don't agree with that. For one important factor in this is that Eversource expected to lose $300 million in that transaction in the sale of that company. And effectively, Aquarion has become a quasi-municipal entity. So Aquarion is actually will no longer be under control of the PURA, and therefore I don't think that that transaction speaks to ongoing expectations about Connecticut regulation, given that the company will no longer be under the regulation of this regulatory agency.
You heard Mr. Rothschild discussing Connecticut as credit supportive. Have you reviewed the S&P and RRA regulatory rankings for Connecticut?
Yes, I have. I believe that's covered in my rebuttal testimony. The rankings for Connecticut have been reduced over time in response to the most recent Aquarion decision, the SCG and CNG decisions by S&P and RRA both. And so those reductions should not be concluded to be supportive. In fact, on my rebuttal testimony at page 83, I identify that as of December 2024, the company's ranking was downgraded from below average 2 to below average 3, which is the lowest RRA ranking.
And lastly, to Ms. Bulkley, do you have any, you recall additional testimony from Mr. Rothschild on issues regarding higher volatility translating into greater risk and a higher cost of equity?
I do.
Can you comment on that, please?
Yeah, so currently, I agree that there's been higher volatility. In fact, the VIX most recently has been at approximately 50, demonstrating significant concern in the marketplace with respect to, the overall market conditions. And equity investors would take that into consideration in the determination of the cost of equity.
Okay, thank you. And Mr. Panici, did you hear questions posed to Mr. Rothschild as various hypothetical scenarios relating to debt issuances?
Yes, I did.
And does the company have real-world experience with respect to debt issuances?
Yeah, I think one piece of information I can share, and we highlighted this in our interim rates testimony, is related to a debt issuance the company is held in November of 2023. All three Connecticut companies were issuing at that time, along with the broader group of Avangrid companies. We priced that through the private placement market, which is pretty typical for these companies given the overall issuance sizing. And through that experience, we work with placement agents and banks to go through a pricing process with investors. Through that pricing and bid process, we had attracted just enough capital from investors to price the UI transaction, but we're actually short by roughly 50% on both the CNG and SCG trades at the time, which required more work from the banks and the investors to get them comfortable with making the trade, and we're eventually able to price the transaction for all three companies, but at a higher cost of roughly 10 to 15 basis points overall for those three companies. So I think this goes back to when you're thinking of pricing between rating differentials, investors are taking things into account even before maybe rating shift. So the SCG and CNG companies were downgraded at the end of last year, but we saw incremental increases in price prior to any official downgrade coming from the agencies.
Okay, thank you. Thank you. The panel is available for additional cross if requested.
Thank you. I'll go back down the line. Authority staff. OCC. Thank you. Attorney Wright. NECTA. Deep. Thanks. EOE. Okay, thank you. All set. Thank you.
Thank you.
Okay. Let's 236. Okay, let's take a break until 2:50, at which time we will begin with the customer service company of the company's customer service panel on page 7.
Thank you. Thank you.
My third rodeo. I know it is. You're all pro now. Came in and last year, my rate is. One of them was my first day at the job. I was gonna say, I think. I don't, well, just tell me where to sit. I just. You.
Next. You. Right, it'll be down there, but behind. Okay.
Let her know you're here.
Yeah, so there's another.
Yeah.
Yeah,
I saw that too. Yeah, thank you. Oh, man.
Behind somebody.
Move down a little bit at my chair.
That's right. Jeff, where are you?
Right here. So I didn't want you right.
Okay. I get right here, right? Please have.
maybe here. Yeah, not side of you.
What it means.
What if you do that?
Right.
Yep. Wow. Here. Downward. Need a slide on sport. Anybody else bring one? Bring what? There's still some room. Yeah, it'll, in case Nick needs.
Look at me.
Usually plug down there. We don't, I don't.
He's got, yeah, he's got one.
Oh, he's got a, oh, we have another strip up here, guys. Mine's underneath.
Huh? Oh.
Getting a picture. UI good.
It's not on. I'm sorry.
Good afternoon, Chairman and Commissioner. Mark Cook for NetSpeed. I apologize I wasn't here earlier today, but NetSpeed has two very minor items regarding the hearing agenda, which I wanted to present in the interest of efficiency, if you'd allow it. The first is NetSpeed's willing to waive its time for cross in the rate panel, which is the second to last panel of the hearing proceedings. and simply reserve the right to cross in the pole attachment panel.
Okay, reserve the right on page 18, full attachments panel, and waive on panel 15,
Correct.
page 15, excuse me. Okay, very good.
Thank you very much.
Thank you, Attorney Cook. Okay. Seeing no other administrative matters, Attorney Vaughn, if you want to introduce the witnesses that I will be swearing in.
Absolutely. Good afternoon. I'd ask the full witness panel to state your full names and positions for the record, please, beginning with Mr. Hurwitz.
Jacob Hurwitz, Senior Director of Revenue Requirements, here on behalf of UI.
Tracy Palella, Vice President of Customer Service on behalf of UI.
Nicholas Daniels, Manager of Customer Care on behalf of UI.
Jeff Drohoda, Director of Customer Care on behalf of UI.
Craig Patterson, Senior Director for Customer Experience and Digital on behalf of UI.
Thank you. And if you have not been previously sworn in, please raise your right hand. I'll be administering the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you. Attorney Vaughn.
Thank you. Mr. Hurwitz, you remain sworn and previously adopted your testimony relating to the company's application for interim rates. Did you also co-sponsor pre-filed direct and rebuttal testimony and exhibits in this proceeding, which were marked as exhibits UI RRP 1 through 27 and exhibits UI rebuttal 1 through UI rebuttal 5?
I did.
And do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in an interrogatory response?
No, I do not.
Thank you. Ms. Palella, Mr. Patterson, Mr. Drohoda, and Mr. Daniels, as part of your preparation for this docket, did you provide pre-filed direct testimony and exhibits which were marked as exhibit UI CSP 1 through 3?
Yes.
Yes.
Did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
Do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in an interrogatory response?
I do not.
No.
No.
Thank you. And to the panel, do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Yes.
And lastly, to the panel, for purposes of admission into the record, have you reviewed and do you adopt the interrogatory responses submitted by other individuals identified in the company's April 24th, 2025 correspondence on witness panels and discovery witnesses in the area of customer service and customer experience?
Yes.
Yes. Yes.
Thank you. The panel is available for cross-examination.
Thank you, Attorney Vaughn. We will begin cross-examination of this panel with the authority staff. Attorney Riley, please.
Thank you, Chairman Gillette, and good afternoon to the panel. Jim Riley on behalf of authority staff. I'm going to start today with the outside call taking vendor expense. That's Schedule C 3.03 WP line 2. And RU 401 will also be relevant. I could let you all pull that up. So I'll begin by saying, so my understanding here is the company utilized a combination of 2019, 2022, 2023, and 2024 call volume data to project its expected credit call volume in the rate year. Is that correct?
That's correct.
And for move in, move out calls, it used 2023 and 2024 data for the rate year. Is that correct?
That's correct.
So 401 Part A describes, I'm trying to understand why the company utilized the combination of years for the credit call volume and the rate year versus the move in, move out. And the response mentions a number of, alludes to staffing issues and anomalies. So can the company please explain the issues and anomalies that the company experienced that led to its decision to choose the years utilized to forecast its credit calls for the rate year?
Yeah, and I know we meant to exclude some anomalies like, and I'm still pulling this up, but like pandemic era volumes and when credit and collection volumes are down. The last few years have been pretty choppy in terms of historical volume. And when you're calculating forecasts, you're trying to put as much science and as little art as possible. And we look back and we'll remove anomalies because it can skew the data. So when we're looking forward, we take a lot of things into consideration. It's not a perfect science, but we will look back at maybe a year that didn't have an anomaly and see if there's any changes and use that in our calculations.
Yeah, so a typical workforce management best practice for forecasting call volume is to look at a data period and then solve and normalize for any volume abnormalities. And that's what we did here. We took a volume that we felt would be representative of our future call volume with a return to shutoffs for non-payment for hardship customers, which occurred in 2019. That did not occur from 2020 through 2023. So that data was excluded. And then, any additional anomalous data we wanted to solve for to make sure that we were forecasting what we felt would be representative of the conditions that would exist moving forward.
Okay, so then I guess what I'm still struggling with is how's that then relating out to move in, move out? You have 2023 and 2024. Why not just use 2023 and 2024 for your credit calls?
Well, there's a couple of key differences there. So we didn't see volume impacts relative to move in, move out through the pandemic. So what really occurred was that we stopped certain collections activity, and in particular disconnections for all customers for a period of time, and the disconnections for customers who were coded hardship. We didn't have that same sort of impact for move in, move out calls, making the 2023, 2024 volume more relevant and usable for these purposes of forecasting. What we wanted to try to do with the credit and collections volume was blend both pre-pandemic and post-pandemic volumes to be more representative of what we thought would occur in the future years.
Okay, thank you. So in part B of that response, it looks like the company also refers to specific digital and automation enhancements applicable to MMO. So what specific digital and automation enhancements were applicable to move in, move out versus credit calls?
So the company has, as we've, and Mr. Patterson, I'm sure can expand upon this, but we have implemented automation of the move-in, move-out process on our websites, and as we've seen digital adoption grow in that area, that's resulted in a reduction in call volume to our contact centers for that particular topic.
Okay, and so then conversely, that wouldn't be applicable to credit calls, so you wouldn't see the corresponding. Okay,
correct.
Understood. I'm going to move to RU 400. And in RU 400, the company stated that it arrived at its 2025 forecast assumptions for move-in, move-out calls by using a 50% call reduction in the 2025 forecast compared to a 2023 actual offered calls normalized. How did the company determine that 50% call reduction factor was appropriate?
I'm not seeing 50%.
Yeah, I can see it. And so, yeah, and this is part of our forecasting process once again. And, you know, it states in answer B right here, there were 3,680 calls. And normalizing that across the entire year is what we do in terms of our forecasting for all calls. And so what happens is, and I can get the exact calculations, but there's some math that goes behind it. But our workforce analysts will go in there and try to normalize call volume over the years.
Yeah, and I think the other reason why, so it's trending, right? So when you introduce a self-service feature like the automation of the moving home process, you're going to see an uptick in folks who use that service, and that you'll see that initial increase in adoption, and over time, the adoption rates and the decrease, slows down over time. So you wouldn't see year over year the same reduction in call volume because the adoption, by and large, had already taken place.
Understood. Thank you. I'm going to move to the customer experience and communications, and relevant here will be RRU 104, attachment 1. Everybody has that up. So I noticed on page 1 has your test year expenses. I think I'm talking about specifically line 24, which is the contact satisfaction survey. And then page 3 on line 25, and I should specify Excel line 25. What's the driver between your test year and your rate year expenses there? Between 2022 and the rate year.
So could you quote the interrogatory, please?
Yes, it's 104, attachment 1.
RRU 104, just to be clear for you, Mr. Patterson, is that?
That's correct, yes. Thank you.
The rate year amount of $25,264 reflected on RRU 104 UI attachment 1, page 3 is simply equal to the pro forma test year amount of $23,668 escalated by the general inflation escalator. The different amount recorded by the company in 2022 as compared to 2023, subject to check, I believe this sort of seems like a payroll order, so I think it would be a function of the time charging of the company's employees, but I would have to check to make sure. But it's a function of the amount recorded by the company in the various years.
So to clarify, so is the company performing an internal? Perhaps I'm
My apologies.
confused with
that
terminology used.
I was confusing the portion of the attachment I was looking at. That is not what this line is.
Yeah.
It is a function of the amounts recorded by the company in 2022 relative to 2023.
Okay, so the descriptor is a contact satisfaction survey. So is that a external survey, or can somebody please describe the line item for me?
Yeah. Yes, it is correct.
Okay, so it's an external vendor that you're paying. Can you describe what the expenses is for? What services are those vendors performing?
Yeah, the outbound contact satisfaction survey agency take interaction records from customers that have contacted us via the call center, website, mobile app, etc. And they recontact those customers to ask them a number of survey questions on their experience as part of that contact with United Illuminating.
And that's following an interface with a CSR, whether internal or external, or how exactly does that work?
Exactly. So it'd be both internal and external interactions with CSRs, as well as digital interactions, so through the website, mobile app, etc.
Okay. And so the 2022, so the tester reported expense was about $14,211. And then your rate year is 25,264. So what's the driver for that increase?
Excuse me. I'll just get the attachment being referenced. Yeah, so the overall cost increase between 22 and 23 would have been directly due to the cost per call. So, post-COVID, we've found just as organizations, as more customers move on to self-service channels and other things, for us to be able to establish a quota, i.e. number of customers that we can survey within a fixed period, we have to place more calls. When you place more calls, costs more money to achieve the same number of surveys.
Okay. So in other words, so the company has a contract with this contact survey vendor. They charge on a per call basis. The cost correlates to calls to the CSRs.
Yeah. Yeah.
And I'm sorry, again, so that's internal and external CSRs they're contacted.
Yeah. So it's I'm the customer.
Yeah.
I contact United Illuminating either via internal or external CSR, or I use the website to self-serve or the mobile app. Any of those interactions are then candidates to be recontacted by our survey company to do that work.
So when you say candidates, is there like a screening methodology, or does this just go to any customer?
So it's randomized. So the survey company select in a randomized fashion from those interactions.
Okay. So it's say like a percentage of your call volume population.
It's a percentage of our customer base.
Okay.
Yeah, so in the prior UI proceeding, we were mandated through Order 40 to cover at least 1% of our customer base annually.
Okay. All right. So that's a vendor that's been in place for how long?
For many years. And this year we're proposing to do an RFP, competitive RFP, from a pricing perspective.
When's the RFP scheduled to take place?
October.
October. Okay.
Yeah.
So the contract terms end September or October of 2025?
So the contract is active until the 30th of September. So we'll be going to RFP pretty much immediately soon to then have a replacement in place or continue the same contract based on the outcome of the RFP prior to the 1st of October.
Okay, understood. I'll move on to, so there's direct mailings and email expenses. How are those charged to the company? So again, is that an external vendor that's charges on a per mailing basis? Can you explain how that works?
Yeah, so generally, when it comes to communications with our customers, be that an SMS text or an email or a bill, typically mailing vendors charge on a per send cost perspective. Yeah.
Okay, and how does the company determine whether to use a direct mailing or an email?
It depends on the communication or customer of choice. For example, if a customer opts for e-billing, electronic billing, then we would not send the paper bill, and we would alternatively send an email.
Okay, so it's contracts both with, so it's on a per text basis then if it's SMS?
Typically. I mean, there are few examples where vendors can bundle a text and they'll say, pay a subscription fee and we'll send up to 1 million text messages, but it would boil down to, as common practice, it would still boil down to a cost per send
Okay,
method.
so text, email, mailings, all on a percent basis. So so again, that's a vendor that the company procures through a competitive RFP.
Correct.
Okay, and that's like usually full service text, emails, direct mailings, or different vendors for different communications.
Different vendors for different communications,
Okay.
typically, yeah.
And they're in place for the rate year, these vendors?
Yeah.
Okay. So similar question, there's an alerts and notification system charged to the company, I understand, correct?
Yes, correct.
And same thing, that's charged on a per SMS or per text basis?
Exactly. So if we use the disconnections notification alert that we send to our United Illuminating customers, that's charged on a per text basis.
Okay, and you have that vendor secure for the rate year as well?
That vendor's currently secure, yeah. We will most likely be doing an RFI this year, so request for information, just understanding the latest capability on the market from a due diligence perspective, because we do think there are opportunities to consolidate some of our communication channels. So rather than having a vendor for email, a vendor for alerts, and so on and so forth, there's technology out there that can orchestrate across multiple channels, and we want to understand those capabilities more. So it's more exploratory, but we do have vendors already in place, but we would like to investigate the market.
Oh, okay, so in other words, consolidate, as we've spoken about in this conversation, email, text,
Exactly.
SMS, and then some of these other services and trying to combine those into one, in other words?
Yes.
Okay, understood. And then there's a number of contact center services in that C schedule. There's inbound fax usage, translation services, and Equifax services. Are those, how's the company charged for those services on a per transaction basis or something different?
The desktop faxing and Equifax are both on a per unit cost, so by number of by usage. And translation service as well is a per minute cost based upon language type.
Okay, so 3 separate vendors for those services as well, correct?
Correct.
Okay, and those the companies can perform competitive RFPs for those as well recently?
We recently, I believe it was 2022, performed an RFP for Equifax. Equifax was selected for the Social Security check. That was an Avangrid Networks RFP. Similarly, around that time frame, we did an RFP for the translation service. I don't recall the last RFP for the desktop faxing application.
Okay. But the contracts for those services are in place for the rate year?
Yes, they are.
Okay, thank you. Switching gears to the fee-free program. So has the company experienced a decrease in transactions using My Account since the fee-free program was implemented?
No, the opposite.
The opposite? Okay. Can you explain that dynamic for me again, really quick?
Yeah, so fee-free, just as a awareness piece, it's removing the upfront charge for making a card payment. So as we've seen that removal through the fee-free program, we've seen the increase in transactions of customers taking the benefit from that program online.
Okay, I see. And My Account's like your web portal for making those transactions?
That's correct.
So what you're saying is as more customers utilize that?
That's correct.
Okay, understood. I'm going to switch gears. Looking back, schedule WPC 303, so we're going to stay there. Is it accurate to classify those services as a customer, or all of those customer-facing expenses?
My apologies. Can you just ask that a little more specifically?
Sure, yeah. So those line items, would they all be considered customer-facing expenses? In other words, they're interfacing with your customers.
Are you talking about like the call taking vendor discussion, like all of the Q&A?
Precisely, yeah, all those line items.
That's right. They're predominantly all reflected on the schedule you've just referenced for the reason you noted.
Okay, thank you. So referencing RU 377, my understanding of the response is that the company in its updated cost of in its LFE1, essentially, it's going to be allocating a portion of the fee-free program expenses to transmission. Is that correct?
Correct.
And so given that the rest of the items are customer-facing, are all of those items also allocated to or is a portion of those costs allocated to transmission as well, or should they be in the LFE1?
It is, and just by way of background, and we've submitted at least one data request on this topic recently, although as I say this, it may have been in a different proceeding. UI filed with FERC and sought approval back in 2008 or so to allocate costs recorded to FERC accounts 901 to 910 between its distribution and transmission operations, where said costs could not be directly assigned to a rate mechanism that is neither one of those things. And FERC subsequently approved that proposal, and UI has maintained its books in accordance with that approval ever since. The reason why a change is required for the credit card fee line on Schedule C 3.03, but not any of the other lines, is because that is the one line where there were no costs recorded in the historical test year. So the company's natural maintenance of its books reflected the allocation between transmission and distribution for all of the other lines. But since this one is just a post-test year item, that did not happen, necessitating our response to OCC, our RU 377.
Okay, so if I could distill that. So in other words, so yes, they are allocated. The fee-free was just that adjustment needed to be made post FERC, that FERC filings that you're alluding to.
My answer to your question is yes.
Okay, thank you. I'm going to move on to a different topic. Does the company engage in any outreach initiatives specific for small businesses? And if yes, can you describe those outreach efforts?
Can you explain further what you mean by small businesses? Like, do you mean like energy efficiency programs, things like that?
All of the above. Just anything that is specifically tailored, I should say, to small business customers.
Yeah, I think there's a different panel on as far as the commercial outreach for energy efficiency programs that they manage, but that would be one of the categories where there would be outreach to small businesses.
Okay. And I guess similar, so any educational resources would also be part of that program as well?
Yes.
Okay. And perhaps I'll reserve this for the next panel, but does the company assign account executives to any small business accounts, to your knowledge?
There is a team of key account managers for the company. They typically are larger accounts and municipalities, but they have been known to perhaps if there's some sort of reason why a smaller business might need some extra attention, they may assign a key account manager to that as well.
Do you know if would the small business need to reach out to the company to initiate that conversation, or is there any other method?
Typically, yes, or if there was some sort of interaction with customer service, and we determined that they may need, some additional support, we may request a key account manager, and it might be just a one-off type thing rather than an ongoing relationship.
Is that specifically like pay related? Like, in other words, if they're delinquent or behind on their accounts, or
Not necessarily, no, just if they need, assistance with managing their bills or, reasons like that. But typically, as I mentioned, the key account manager group is typically larger accounts and municipalities.
Okay, understood. Thank you. Okay, thank you. I'm going to pass it on to my colleagues.
Good afternoon, everyone. Janelle McGregory, staff attorney for the authority. I'm going to start with questions regarding ROE reduction, specifically looking at CAE1 attachment 1. Give you a second to pull it up.
I think we have it.
You have it, okay. In the company's response to interrogatory CAE1, the company referenced various customer care metrics and that they have improved since 2022. For example, the company stated that average speed of answer, customer correspondence time, and call abandonment percentages all improved since 2022, and that the increase in customer service representatives are the reason for these improvements. Are there any other potential factors that impacted these metrics outside of additional CSRs?
Yeah, it's from a digitalization perspective. We've introduced new capability, such as the moving home process online that we discussed a moment ago. We've added additional support capability on the website for billing and payments, as well as enhanced app capability. So increasing the self-service footprint is also another key driver for supporting an improvement in overall customer self-service metrics.
Yeah, and is generally indicative of a large scale KPI improvement. There's multiple factors that are involved, but the correlation between staffing and speed of answer and abandon rate, those are directly correlated, right? We look at speed of answer, service level, abandon rate, what we're asking and what we're tracking are, do you have the right people in the right place at the right time? Because if you don't, then you're going to see an increase to those metrics. And so the staff additions were certainly a part of that. The volume that we've been able to deflect through digital channels is certainly an impact to those metrics as well. But those staff additions in combination with the digital deflection was able to combat the increasing average handle times, which is a product or is a portion of your workload, right? So how many calls do you have? How long do they take? What's the total amount of work? And in order to keep up with the increasing workload, those staff additions were necessary.
And the other aspect, as Mr. Daniels said, there's a lot of different components. Another one would be just active performance management. So working with and coaching representatives and making sure that they're being as efficient as possible in their call handling aspects. So that could also influence in a contact center environment, influence performance as well.
Thank you. Were the additional CSRs hired at the internal call center or the third-party call center? And if third party, was it ICOR or Alorica?
So when you reference the additional CSRs, the 12 CSRs that were the 12 CSRs that were approved in the 2022 rate case?
It's the additional CSRs that you referenced in CAE one.
Yeah, those are internally hired CSRs, so they work in the center in Orange, Connecticut.
Okay. When were those additional CSRs hired?
I believe we have an interrogatory response that refers to when we got to our full staffing levels. So we're keeping up with attrition while we're hiring. There isn't a specific, we hired them shortly after the rate case, but as we had attrition, I think we got to our full staffing complement, subject to check. I want to say May of last year. But I believe that's about the time where we got to our fully approved staffing level.
Okay. The company states that additional CSRs helped address the increased workload from implementing the low-income discount rate. However, the LIDR was not implemented until 2024. How did LIDR implementation impact these metrics between 2022 and 2024?
Yeah, so there was quite a bit of pre-work that needed to be done in a large scale project like the low income discount rate. We sent out communications in advance, and in advance of the discounted rate going into place, customers were calling and submitting documentation in order to qualify for the launch of the discounted rate. So we saw an influx in hardship documentation that needed to be processed. Had it not been for staff additions, we likely wouldn't have been able to have the turnaround times that we had without giving much more overtime or those types of additional resource opportunities in order to again compete with the additional workload. Also, the testing involved in being able to do user acceptance testing for the system enhancements that were in place. Those were all heavy resource requirements.
Yeah, just to supplement that, the pre-enrollment was around August of 2023. So that would have tied into some of Mr. Daniels' comments about early activity ahead of the actual start.
The company states that the first call resolution rate has improved. Can you provide the rates between 2022 and 2024, and how have they improved?
Could you perhaps point me to line 22?
Is, just to clarify, is that what you're referencing, the line 22, improve first call
Yes.
resolution?
So to some degree, that is anecdotal, and just by the fact that our process dictated that 2 calls were required to handle this particular scenario. For customers who are calling in and around their meter read date, because of the timing of their call, they would need to call back a second time to be actually placed on the arrangement. When we took a look at that process and adopted a change, we negated the need for that second call. So, to some degree, it's anecdotal, but we know through call listening and when customers call how often that does happen. So it was impactful. We do have first call resolution statistics. I don't know that we have them going back to 2022, however.
Okay. Can the company explain further the follow-up tool implemented as part of enhanced SAP functionality and how CSRs currently use it to improve potential follow-up actions?
So the follow-up tool was recently implemented within the last several weeks, actually. So I wouldn't have much data to talk through those changes, but in essence, the follow-up activity is a way to track within the customer information system necessary follow-up actions by a CSR or perhaps an external department. It could be as simple as I need to call this customer back, or it could be that we need to reach out to another part of the organization to do follow-up on a customer inquiry. And we're able to track that, see how many instances there are, see the aging, so that we can follow up as necessary, and then also ensure that the follow-up activity is actually being performed.
Regarding if the follow-up tool tracks the reason for following up, does the CSR provide incorrect information? Does the customer need to provide additional information? Is that tracked by the follow-up tool?
Can you repeat that again?
Yeah.
Please.
Can the company explain if the follow-up tool tracks the reason for following up?
So there are categories that CSR would select when creating a follow-up activity.
Okay.
And then additionally, there would be, there's a requirement to make a note specific to the work that needs to be done. But in general, we can get different categories of the type of work that needs to be followed up on.
Okay. Regarding the quality assurance metric, the company states that Alorica has achieved an 84% success rate on energy affordability calls in 2025 to date. Can you provide more information on that? Specifically, what is defined as success here?
Yeah, so we monitor Alorica. Alorica is the only vendor taking calls for us right now. So we do a certain amount of reviews. We have a whole quality program that we've entered into testimony, into interrogatories. But we track the progress and the accumulation. It's all pass-fail. So 16% would fail. It's the live call guidance that we're using, and we have a form that's tailored to the live call guidance, which we've submitted as well. So we just go down the list, and if the rep misses something, it's a fail. And so currently, 2025 year to date, of all the reviews that have been done, we're sitting at an 84%.
Okay. Are successful Alorica calls incentivized by the company, such as with financial bonus for greater success or penalty for missing the goal?
Neither at this time. The expectation is that they perform and produce on these calls. Penalties has been discussed for a couple of years. Still, there is nothing in the contract right now that penalizes them for a certain amount. But, a direction we're always looking at.
We obviously, we do have penalties in place for customer escalations where it's found that there was fault by the call outsource vendor on that particular call. But in reference to a specific KPI, relative to pass fail on energy affordability and how we're scoring calls, no, there isn't currently an incentive or a penalty in the contract.
Okay. Is every energy affordability call reviewed by a quality analyst or only a subset of such calls?
Only a subset. And it's a manual process right now. So if it's a 15-minute call, you have to have somebody go in there and listen to it, sometimes twice. And so you just don't have the staff to listen to every single call, but you can listen to a subset and try to glean trends at the call center level and the individual level.
All right.
Yeah, I mean, just by example, UI last year in 2024 handled, over 128,000 credit and collections calls. So, virtually impossible to listen to every one of the calls, but what you want to do is listen to as many calls as it makes sense to, given the staffing needs associated with that type of work. So, we endeavor to, based upon agent tenure, listen to a certain number of calls per representative each month.
Okay, thank you. Has the company assessed the success rate of all energy affordability calls regardless of which CSR, internal or Alorica, conducted the call? And if so, what is the success rate?
So we haven't really done a comparison, internal versus external, because of the way that we've programmed our IVR. Most customers, the exceeding majority of customers who go through the IVR, authenticate, and choose the correct selections, they're routed toward Alorica, our outsource vendor. We generally, if we receive a call in the internal contact center, it is handled by an internal CSR. However, to locate those calls, because it's not tagged as a credit and collections calls, is very difficult. It's kind of like searching for a needle in the haystack. So we don't generally score those calls unless by chance we come across those. And further, if we do score those calls, it would be the internal supervisor scoring that call would be using the full credit quality assurance evaluation form, and not the energy affordability live call guidance evaluation, which is pass fail.
Thank you. The company states that a benchmark of 41% was measured. When was this benchmark measurement collected? In other words, what time period was included in the measurement and which CSRs were included in it, internal, ICOR, and or Alorica?
So the 41% benchmark came out of the 2022 UI rate case, and it's part of the complete and accurate customer information metric associated with executive compensation. So the order there was to benchmark historical results to come up with a target for improvement.
Okay. Okay, moving on to CAE 15. Give you a chance to pull it up.
I have it.
Okay, great. Thank you. In the company's response to interrogatory CAE 15, the company explained that an internal complaint may lead to a penalty being applied to Alorica if an Alorica CSR was not in compliance with company policies. Can you explain what type of complaints reach the internal escalation team?
So I'm assuming you're referring to the customer escalation team, also known as a review officer?
Yeah.
And that's typically how we would classify a complaint reaching an internal team. And that's done either through a customer reaching out to EOE, or through a complaint that comes in through a customer through the Better Business Bureau or through our executive offices. Those are deemed customer escalations. We research each escalation that comes in through the company, and if we find that this was a result of an interaction and misinformation or improper handling by a CSR, then yes, a penalty would be assessed to the vendor.
Okay. And does the company and or Alorica's quality assurance analyst track trends in calls? In other words, if there are a number of calls where CSRs are providing similar incorrect information, is that tracked in order to identify potential gaps in training or a potential non-compliance from the vendor?
Absolutely.
Yes, so we have a pretty robust process in place with Alorica right now to ensure, even to the rep level. And since we started transitioning in March, placing a bunch of attention on each individual as they come through the program. And, you know, if they're not a right fit for the program, we make that decision. It's not a skill set that everybody has. It's a very complicated call. So we have quality monitors and huddles and feedback. We've had boots on the ground. So yes, we are, and we have something in place long-term now that the ramp is over. We need something, we have something in place long-term to ensure that the quality remains high and gets better.
There's also a regular, I believe it's biweekly review with the leadership teams, internal as well as the vendor, and they review quality scores, trends, and the follow-up that's taken place related to that. So there's a formal process to review those as well.
And I would say we elicit feedback in other ways besides, you know, quality assurance scores is one way to elicit feedback on customer experience, but also through our survey mechanisms, customer escalations, you know, reviewing when we're doing call reviews through our quality assurance processes, and we're looking for trends and looking for opportunities where training might need to be updated to reflect more clarity or additional guidance or where we need to be, you know, more robust in our training materials. So that's an ongoing process from a variety of different channels for the company.
Yeah, we also have a customer satisfaction meeting amongst all of our customer service managers, and we meet with the escalation manager and review all of the calls that they have received and handled, looking at the trends, identifying any root causes and any next steps.
Thank you. Switching topics to customer experience projects. I'm going to start with CAE 50, attachment 1.
Yes, I've got it.
Okay. Can the company clarify whether the customer service initiatives listed in CAE 50 are in process? And if so, can you clarify which projects? Or are all of the customer service related projects that are included in the revenue requirement request in this proceeding all proposed projects?
Well, maybe split that into two questions, if that's okay. So
Of course.
the first part of the question is just in regards to have all of these projects commenced.
Yes.
So I would say it's mixed. Let me just
Yeah, the first one, I'll kick it off. The bill redesign project has completed.
Okay. And then did you need me to repeat the?
Yeah, no, I can continue through do we want to do line by line?
Sure.
Okay. The customer experience enhancement. So that's a program that we started 2 years ago, and we've delivered some of those initiatives, such as the moving home one, as an example. And then the majority that we have in here are to be delivered. Digital Customer 360, line 4. Again, we have 2025 scope stipulated within there, with some of those initiatives started, some still to occur. Line 5, the digital tech lifestyle and upgrade. So this is really like a maintenance program. So that'll continue all the time. That's like, you know, in electric operations, like reliability work, and making sure we keep the lights on, because we have over 83% of our customer engagement comes through digital channels now. So they expect a 24/7, 365 service. So that's essential maintenance. The energy manager enhancements we have, we've yet to do. Miss Plello will probably want to answer line 7.
Yeah, the low income discount rate, we are starting programming for the 5-tier that is to be in place for next year.
And similarly, Ms. Plella for line 8.
The time of use. My miss.
Yes, I mean, I think there's obviously, sorry, I'm just reading through the detail.
Yeah, I think the time of use assessment was line 8.
Yeah.
Correct? Yeah, that's my understanding is the assessment of the proposals for time of use and the next generation time of use. So I think there's an assessment. So that's still in place. That's something that's slated to happen.
Yeah. And whether there's, if it's opt-out or other definitions as part of that program. The kind of UI, we've got the digital journey. So again, we have made enhancements to our digital experience, but in here we have a number of others that we wish to proceed with. And again, we've got the results of what we've done so far in column H within that program. And then the UI Green Button Connect, that's not a program that started. However, we've provided feedback and recommendations to put on that.
Okay, thank you. Regarding CAE 50 attachment 1 as well as CAE 40, I'll give you a moment to bring up CAE 40.
C 40 or 14?
40.
40, thank you.
I think we're all good. We have it up.
Okay, great. Just trying to be patient.
Thank you.
No problem. So in the company's response to interrogatory CAE 40, the company shares all LIDR implementation costs that were incurred between 2023 and 2024. Can the company confirm whether these are the total LIDR implementation costs incurred until 2025?
I believe these were the costs at the time that we responded to this interrogatory. So those included the work in 2023 with the implementation of the program as it stands today. And then 2024 was some post-implementation testing, some corrections to perhaps some issues that arose. And then I believe there's some costs associated. We made some changes to the Department of Social Services matching programming. So that's what these costs represent.
Okay. Can the company clarify whether any LIDR implementation costs were recovered through the annual revenue adjustment mechanism or RAM proceeding? And if so, can you provide which RAM proceeding these implementation costs were recovered through?
My understanding is these type of implementation costs would not have been recovered through the RAM.
Can you explain why?
Just as an initial matter, these represent capital costs, and largely capital costs have not flown through the SBC, or now to be called the EAC. There may be other reasons, but that's one at least.
That's my understanding.
Okay, thank you. So if the company did not recover LIDR implementation costs through the RAM proceeding, can the company explain why it did not request, well, you kind of answered that, but can you explain a little bit further why you did not request those costs through RAM?
We would have to check our notes to see if there were more specific directives or guidance, but largely this is, as I said before, a capital project. These are capital in nature. You can see references to the supporting testimony of the capital investment panel, and we have included them as an element of UI's overall distribution rate base in this proceeding for that reason. And UI, to my knowledge, has not recovered its distribution rate base through the RAM in any years in recent past. So I'm not sure why it would be appropriate to change that for this approximately $1.1 million capital project.
Can the company clarify whether it is requesting to recover the LIDR implementation costs incurred between 2023 to 2024 in this proceeding? If so, where is the company requesting that? Specifically, what exhibit and line item?
Again, these represent capital costs that are included as an element of our proposed rate base in this proceeding. The specific numbers you see in CAE 50 UI attachment 1 on the tab called CAE 50 attachment. It is Excel column B labeled capital project ID. On the tab called cost components, it is Excel column A labeled project ID, but both of those columns provide a very specific and discrete letter number combination for each one of the projects my colleague just ran you through. Those correspond to specific elements of the capital plan that are further reflected in the company's proposed plant model exhibit UI RRP3. It's one of the exhibits to the revenue requirement panel's testimony. And you can see in that exhibit these specific projects getting included in the computation of our rate base, and you can see the specific capital project IDs from CAE 50 on tab 4.1 plant additions detail. That then rolls through our various rate base schedules, including B 2.0 and B 1.0.
Was that 2.0?
B 1.0.
Passing it over to my colleague.
Hello, Jenna Vigras, staff at the authorities. Thank you so much to the panel. I just have a few follow-up questions just to clarify some items from my colleagues' questioning. So first, I wanted to go back to some of the energy affordability call information. So the company stated that when internal CSRs handle energy affordability calls, that is not tagged. Does the company have the ability to tag internal calls as energy affordability calls?
Not at present time. So the way that we can search for specific types of call recording, as a customer flows through the IVR, the call itself is flagged with certain data and identifiers. If a customer gets to our internal contact center, that would mean that they didn't follow the normal or typical path for a credit and collections call or an energy affordability call. So therefore, the tag that they would have would be associated with a different call type. So for instance, a customer who selected options in the IVR for outage when it's actually a call related to energy affordability, we'd see that as an outage call, not an energy affordability call.
Okay, that's helpful. Thank you. And my understanding is the company has a speech analytics tool that you can use with kind of reviewing calls. Does the company have the ability to use that tool to kind of look at your internal calls and identify calls that address energy affordability?
To a degree. However, our use of the speech analytics tool to this point has been relatively elementary, as it does take quite a bit of fine tuning and honing in order to get the results that we would want to see, or to be able to pinpoint and identify particular call types. The company is in the process of implementing a new contact center technology platform, a cloud-based platform, which we believe will allow us to better identify call types and use features like artificial intelligence and speech analytics to better identify and really hone in on particular call types, and understand where we may need to make changes, or to be able to gain insight into data using that platform.
Okay, thank you for that. And can you explain further why, if an internal CSR handles an energy affordability call, why that would be reviewed using the full quality assurance evaluation rather than the energy affordability evaluation form?
Well, it's generally not known until you get into the call what it's going to be. And the normal process for a supervisor, when you're looking at the full evaluation form, there are, some opening elements to, was the correct greeting used? Did the CSR follow the proper procedure for identifying the customer? Were they willing to help the customer? Those sorts of things. Where if they started that form and then realized that it was an energy affordability call, they basically doing double work. They'd have to fill out, start one form, stop using that form, go to the next form. It'd be kind of counterproductive.
I understand, thank you. And does the company have a timeline in that you are planning to kind of fully launch the speech analytics tool and able to use it to kind of identify calls or identify issues, et cetera?
Yeah, not an exact timeline. The vendor and everybody out there is pursuing AI, right? At a huge pace. So we're relying on our vendor. We've seen some initial demos, and it's pretty phenomenal what you can see from AI. But our current vendor that we're going to, they don't have it fully vetted out yet, but they're talking like months, not years. And we won't be the first to go, but once we go to this new vendor, we will be switching tools. We believe this new tool has greater functionality, fewer bugs, and AI capabilities will be coming more quickly. And we expect that this year. And we will be able to use speech analytics across both Lorica and internal calls, which will be nice.
And part of the reason why, maybe we haven't gotten some of the results that we would have hoped with our current speech analytics tool just really has to do with where artificial intelligence has gone over the last couple of years, right? Where it's really exploded. You have the introduction of large language models, which was really like natural speech recognition that can compare, what's being said on interactions to, a large language model, which is basically the entire English language and able to decipher. Whereas the product that we had in place, and which is typical of products that were in place at the time that we selected our speech analytics platform, deals more with phonibs and putting in keywords and phrases that it's mining against versus, like I said, the use of large language models. And that's really been one of the largest advances in AI across, all of our industry. And I think, Mr. Patterson will probably speak more about how that's, kind of exploded over the last several years.
Yeah, I mean, I think just to follow on from Mr. Daniels there, the opportunity is extensive in regards to scaling up what are now manual tasks such as like quality checks and evaluations of speech analytics, etc. and both utilizing, the new platform that Mr. Daniel alluded to, that we'll be moving to from a telephony perspective, as well as building out some of our own data models, some of which are covered within the Digital 360 customer project that we've recommended for recovery internally, and building out that own capability within United Illuminating is really crucial for for increasing the quality of our service operation.
Great, thank you. And just to clarify, so the company has hired an FTE to handle the speech analytics tool. Is that correct?
Yes.
And I know, I'm sure that this is included in Discovery, but could the company clarify when that FTE was hired?
Yeah, I believe that was April 22nd of 24.
Okay.
So yeah, and they were brought in it took time to actually implement the tool, go through training, get some initial topics in there. You have to go back and listen to the calls. So it's been about a year and they're making great progress. He is, but a lot more to come, I would say.
Great to hear it. Thank you. So I just wanted to clarify, so the internal complaints that were referenced, are those all complaints that originate from EOE that make it to the company?
The review officer and
Yes,
her
yeah.
findings.
I believe so, yes.
Yeah, and so I just want to be clear on that too, because it can come from Pura, it can come from EOE, it can come from Better Business Bureau. What I want to clarify is it's not our analysts just sitting there and if they find a mistake, they walk over and we find them, and so we've made that distinction. But there's always room to do things differently in the future if we determine.
Yeah,
to.
just to clarify that in addition to, so Attorney General, Better Business Bureau, Department of Consumer Protection, executive complaints that come internally, legal aid, PURA, and social service agencies. So it's a number of sources, including internal escalations through company employees.
Okay, great, thank you. And so moving back to CAE 50 attachment 1, I just wanted to clarify what the requests for recovery. And so I wanted to confirm, is the only project that is listed on there that has been completed, is it the bill redesign project?
Yes, that's correct.
Okay, thank you. And then there are other projects listed that are the company is requesting for recovery that like pieces of it have been completed or begun, but the overall project has not been completed. Is that correct?
Exactly. So you'll see, for example, the moving home one is requested for recovery within the current rate case, and then the others are within the application.
Okay, great, thank you. And so to focus on the low-income discount rate, is that the costs that are associated with this, it's labeled rider LiDAR, those are all associated with costs that have been incurred to recover those costs, or do they include projected costs associated with potentially the 5-tier implementation, et cetera?
I need to double check that. I know that the exhibit that we were looking at before, which was 2023 and 2024, those were obviously implementation costs. I think I just need to double check on the if there's any costs in there as far as the development.
Okay, thank you.
Where they are.
And so to return to the exhibit that we referenced earlier with the LiDAR cost, which I believe was in CAE 40. So my understanding is that those are not the total implementation costs associated with implementing LiDAR. Is it correct that some implementation costs were recovered through the RAM proceeding?
My understanding is the implementation costs were included in that exhibit, the total implementation costs, which basically were the programming, the testing,
Okay.
post-implementation testing, et cetera. My
Okay.
understanding, those are all captured in that exhibit.
All right. So the IT consultant cost to test the implementation of the low-income discount rate is being captured in these implementation costs in CAE 40. Is that
Yes.
correct?
Yes.
Okay, thank you. And so the capital costs do not only include like the purchase of software or something along those lines. It's like staff hours.
Correct.
Okay,
Yes.
I appreciate that. Thank you. Okay, thank you. And so, Chair, I'm wondering if the company could offer a read-in to potentially supplement CAE 40 as well as the request for recovery that is included in I believe it's Exhibit UI CIP 5, line number 154. And to provide what component of that request is for costs already incurred as compared to projected costs for future LiDAR implementation.
Yeah, we can do that.
The company can do that as a read-in.
I just want to clarify the exhibit reference.
Okay.
Attorney Vigras, can we just clarify, you mentioned an exhibit CIP and I.
5.
Could you just provide it one more time for us?
Sure. So my understanding, and this is referenced from CAE 50 attachment 1, but that identifies exhibit UI-CIP-5, line number 154 as the request for the rider LiDAR.
Got it. Yes, we can do that.
Okay, thank you. I'll mark that as read-in A.
And is the company planning to request any, I'm assuming the answer to this question, but any costs associated with implementing LiDAR in upcoming RAM proceedings or
Can we take a late file to answer that one?
Sure.
I'll do some follow-up.
Okay.
Okay, so there'll be late file exhibit 3. Discuss whether the company intends to seek further cost recovery of LiDAR in a future RAM.
Mhm. Thank you. And those are all of my questions.
First off, okay, very good. Thank you. I believe we can begin cross-examination by the Office of Consumer Counsel, please. Bring the blanket tomorrow. Yes.
Thank you. Kim White, OCC. Gonna hope my voice holds out here. So I'm gonna start with a couple of quick questions that are some follow-up to some of the things that I heard you say to the authority a minute ago. Let's see. You were talking about
I apologize. I'm glad the volume's working.
multitasking. Regarding call volume, does your call volume projections, do they include, did they factor in data sharing?
Can you explain?
Yeah. So did the numbers on the, so actually, let me just take a step back. When was data sharing implemented?
So DSS data sharing opt-in began in the end of 2023, subject to check. As far as whether or not call volume projections take into consideration data sharing, I think we're looking at historical trends in volume. And to this point, what we've seen even with data sharing is that we haven't necessarily been able to correlate reductions in call volume based on data sharing. And some of our processes still require, although data sharing exists, especially for things like tier upgrades and for initial enrollment onto LIDR through DSS. I think we haven't seen volume drop off as a direct correlation to data sharing. And that we haven't accounted for, data sharing in future call volume projections because we haven't really seen the correlation since data sharing has been implemented.
Okay. When did, you mentioned opt-out data sharing. When did, or you mentioned opt-in. Were you saying opt-out or opt-in data sharing began in 2023?
Opt-in was December 2023, I believe.
So when did opt-out begin, the large data sharing file that we do right now?
Opt-out was April of,
April 2024.
Okay. And
oh, sorry, that date was the change with only enroll in tier 1 instead of tier 2 automatically. That was April 2024. I think I just have to confirm the opt-out.
Yeah, and further with the implementation of a 5-tier level, without having all the factors determined on how data sharing will be done, I don't know that it would be prudent to factor in data sharing into a forecast model without having a measured historical pattern associated with post 5-tier implementation.
You mentioned Equifax in one of your questions. What services does Equifax provide to you?
They do a social security check. So when a CSR or if a customer is attempting to start service with us and they're not an existing customer, we do a positive identification search based on social security number, using Equifax's tool to validate identity and address for the customer moving in.
Does someone have to give you a social security number to start a new account?
They do not.
So then in that instance, how do you validate the customer if they don't give you?
So in an instance where a customer does not or chooses not to provide social security number, although it is, the recommended approach, if a customer does not wish to provide a social security number, they can provide 2 forms of IDs that is in consistence with our regulations here in Connecticut.
Okay, and another response to Cross that I heard a minute ago, you were talking about, and I'm going to paraphrase here, determining the CSR's fit and making sure the right people are in the right job and can handle the cause. How long have you been doing that?
Well, I think that's wasn't exactly what I said.
Actually, I think it was Mr. Drohoda with who
Yeah, so since Alorica inception, we've been doing that, but we've also, specific to EA calls in Alorica, we've been doing that since the very first class, but we also do that for other call types, and we did that with ICOR as well.
You did that with ICOR as well then, back when you had, when ICOR was the credit and collections vendor?
Correct.
Okay. Okay, I'm going to turn to some specific interrogatories now. And I'm not sure. I'll tell you the interrogatory number and give you a chance to go there. I'm not 100% certain. You need to look at the interrogatory every time. EOE 12. Let me know when you're ready.
I think we're good.
So in that interrogatory, you stated that you could have reinstated security deposits for non-residential customers as of October 2023, but you did not. Can you explain why you haven't done that yet?
Basically, it does require a programming change and in a sense, a project. And we've been, the team has been focused on many different projects during this time frame, including the changes to the low-income discount, the matching payment program, et cetera. So we chose to not do this in addition because we felt we did not have the appropriate resource to allocate and make sure that this was done effectively.
I'm sorry, apologize. Could you describe like what the programming change needed for this?
I don't know all the aspects of it, but you definitely have to change the way it's programmed in the system. You'd have to make sure the appropriate letters were going out, to make sure that the removal aspects work. So with any change, you need to make sure it's the changes in the system, testing every aspect of it, making sure that everything works as expected, including when the payment is when they fulfill the obligations and you can return the deposit. So there's several aspects of this that require programming.
Did you collect security deposits prior to the COVID pandemic?
Yes. One moment. Yeah, I believe that was for non-residential only.
Okay, which is, I believe, what we're talking about in this situation.
Exactly, yes.
So I guess I'm having a little bit of trouble understanding why we can't just flip a switch and turn it back on.
I wish everything was that easy. It's not. And you run the risk of doing something incorrectly and negatively impacting customers. And with so many things happening within the system, we opted to not do that right now, but it definitely is on our plan.
Okay, turning to excuse me, EOE 127.
Have it up.
So the interrogatory response states, a bank statement is considered valid proof of income for hardship if the customer receives direct deposits for either Social Security, child support, alimony, pension, or retirement payments. So I just want to make sure I understand that statement. Are there, if you receive any of those items, if you receive alimony, period, a bank statement is all you need to qualify for hardship?
So you would have to provide proof of income, I think. So and also household income size. So if you receive alimony, that would be a portion of your income, or it could be your complete income. So we could use a bank statement to validate that those payments are being made to whoever is receiving those, and then also take a look at household size to determine whether or not the customer meets the the state median income guidelines to qualify for hardship or other programs.
Okay, I guess what I'm trying to understand though is, so those would be, to the extent, some of the things listed, alimony, child support, retirement payments, things like that. I guess retirement payments not.
I would say that it's not typical for a customer to send us bank statements to qualify for hardship, but we are able to utilize those documents to assist qualifying a customer for hardship. The exceeding majority of our customers are qualified through DSS data sharing, or they're sending us copies of their budget sheets or other or pay stubs, but we are able, if a customer has that as their only means of providing us documentation of their sources of income, we will accept it.
Okay, so that's really what I'm trying to get at, is that it needs to be their only means. So for instance, you couldn't just say, I receive alimony, I'm going to send you my bank statement. And
That wouldn't be the recommended approach. That we would ask them for, can we have copies of, your pay stubs? I don't receive pay stubs. The only thing I get is alimony. Can you send us, some sort of documentation of that? And I think that would be an instance that would be, few and far between where we would be requesting that. And again, that's a means to work with our customers, and it's not a typical practice for us to accept that.
okay, and it also says Social Security, but does receipt of Social Security does that suffice to qualify for someone for hardship?
There's different types of Social Security. So it could be a qualifier. We'd along with that, for in the instance of Social Security, would need likely their budget sheet in order to say this is the type of Social Security benefit the customer is receiving. However, if it's just Social Security income, right? So in a scenario where there's one person with income in the household, and it's a household of four, Social Security, income could potentially qualify for them for hardship. It wouldn't be an automatic qualifier like, Social Security, disability, but yeah.
EOE 222, please.
I have it up.
Okay. So I want to make sure that I understand the interrogatory response correctly. So if a customer was on BFP and they failed due to not making payments, then is the interrogatory response saying they could either make up their missed payments and re-enroll, or they could not make up their missed payments and re-enroll?
To be back, so the way that BFP worked, because it amortizes your total balance, a customer could get back on BFP if they made up their missed payments, or we could create a new BFP plan, which would incorporate their arrearages that are more recent into the calculated amount, which would tend to create an increase in that budget amount, or that payment, a monthly payment amount. So the customer would have two options. You can either make up your missed payments or and get back on at the same amount that you were on previously, or we can reamortize that amount and give you a new amount to pay monthly.
So BFP doesn't exist any longer.
BFP does not exist anymore.
When BFP existed, how many times could a customer fail BFP and go through that process that you were just describing?
They would be removed after two missed payments. However, they could re-enroll. There was no limit on the number of times that they could re-enroll.
Okay. Do you recall what authority decision or motion ruling or approved that process?
Off the top of my head, no, I,
Could we get that as a read-in maybe? That would be an easy read-in.
Can you just clarify the which process you want to confirm?
Yeah, the process where a customer could fill BFP
then
and
just
continue
continue
to
to-
re-enroll on
Okay.
it for,
Thank you.
Is read in B?
EOE 229, please. Phase one and then get C, and that would complete phase one, and then they'd go to phase two if they did the two components of phase one.
correct.
Okay. So I guess what I'm trying to clarify in this particular call is the CSR told the customer they had to get SEEP before they could enroll on MPP. Is that right?
So in order to be placed on MPP, we did require a SEEP commitment, and that's part of what drove our auto enrollment process prior to this year, is we would automatically enroll customers who had received SEEP before, since it was a requirement.
Okay, I want to go back, make sure that you and I are understanding each other and what we're saying here. You're saying to be enrolled on MPP, a customer had to receive SEEP. So they couldn't start MPP in phase one, be making their payments, and then at the end of phase one, when they receive SEEP, get their match for all of the above?
Yeah, so the only way a customer would have been enrolled without receipt of seat in phase one would have been if they had received SEEP the year before and were automatically enrolled. So a new customer, having never been enrolled in MPP or receiving SEEP, would have to provide documentation of SEEP for us to enroll them in MPP in phase one.
Okay. Okay, so then the statistics that in the energy affordability dockets of the customers who failed phase one because they didn't receive SEEP, they would have only been regarding customers who were automatically enrolled in phase one from the year before.
Correct.
It wouldn't have involved any new
Yeah,
customers.
so they would have fallen off in after phase one. They would have been automatically enrolled, did not receive SEEP or did not obtain SEEP for that year, and then as a result fell off of the MPP.
Okay, thank you. OCC 827, please.
I have that up now.
Okay, so 827, I think it was maybe 825 to 827. We asked you a few interrogatories regarding what occurs with hardship documents. And I just want to clarify that I understand all of the responses put together. So when you receive someone's hardship documents, you retain a hard copy of the document for 6 years?
Just so that I understand correctly, if a customer sends us in a physical copy of their hardship documents, no, the company's current process is to scan that item into an electronic format, which is then processed by a CSR attached to that customer's business partner within the customer information system. The physical copy is destroyed. And I know that there were a couple of different responses regarding records retention schedules and specific to this. And so I think if we haven't already done that in our responses, which I think we endeavored to do, was to clarify that there is currently, as far as our records retention are concerned for customers sending in documentation that's attached to their account, that's there for the life of the system or until we remove it, moving to another system, or but a physical copy is no longer retained for 6 years.
Okay, so you scan it and it becomes an electronic copy at that point, and the electronic copy is attached forever to the customer's account?
Currently, it is for the life of the system. We are pursuing an upgrade to our SAP system, and we are having conversations with our IT resources as well as sister companies about record retention schedules for those sorts of documents, and trying to come up with a consistent process that makes sense in terms of system bandwidth and also the need. So we'll be going through those processes as we move towards an upgrade of our customer information system.
Okay, and does that, the electronic copy that's attached to the account, does that apply to any sort of hardship document? So if I sent you my W-2 or my tax return or whatever, my paycheck stubs, period, that gets attached to my
Yes.
account, stays
Yeah,
there
and
forever.
if you send that via email, right, in the PDF format, we would then attach the PDF to the customer's account.
But also to clarify, as I said, in the set of interrogatories that we asked, even though it's attached to the customer's account, you don't have any way of querying that to know what tier a customer should be on in lighter right now. There's no.
No, it's not in, I guess, advanced enough for us to be able to do either keyword or look for particular document types. It's really just a repository on the account to store attached information.
Okay. Okay, OCC 832, please.
I had that pulled up.
So to clarify, if someone sends you their hardship documentation, they would, in the initial phone call, if they had an arrearage, they would have been enrolled on a flexible payment arrangement. And after they send you their hardship documentation, they'd still have to call you then to be enrolled on MPP. The hardship documentation doesn't trigger it in any way.
No, attaching documents to an account wouldn't trigger an auto enrollment into MPP. In its previous version of MPP, now with the twice annual MPP auto enrollment, if a customer has a qualifying arrearage and is also coded hardship, they would automatically be enrolled into MPP. But prior to November 1st, that would not have been the case. They would have needed to call us back after the documentation had been submitted in order to be placed on MPP. And there's several reasons for that. We would, in order to calculate MPP, you have to be aware of what tier level the customer is going to be on, and that's dictated by the documentation provided. So in order to quote the customer the appropriate MPP budget amount to get them to and have them agree to that amount to enroll in MPP, it was a requirement for the customer to call us back upon receipt of documentation to discuss the budget terms.
Okay, so if a customer called you in the winter moratorium, and so when they called and they were going to send in their hardship documentation, they would have been put on a 60-day hold, right? Or
If they would have called us during the winter moratorium, yes, they would have received a KLOC, which is a 60-day hold to submit hardship documentation.
okay, so if that customer at that time didn't start a flexible payment arrangement, they just continued in the moratorium, would anything have happened prior to the end of the moratorium for that customer regarding MPP?
No, they because they had the lock on their account, they would not have been subject to disconnection.
Right, But I guess my question is, when they, May 1st comes up, they sent you their hardship documentation, but they didn't ever call you back to enroll in MPP, nothing would have happened. They'd be subject to termination come May 1st. If they had an arrearage.
Are we talking present day or this, or a scenario a year ago? Because present day, they would have been auto, and we just ran an auto enrollment, I think the 31st of March. So that would, if they got a qualifying arrearage, we received their hardship documentation, they would be automatically enrolled into MPP.
Okay. And but not present day in a year ago, obviously that wouldn't have happened.
That would not have happened because there was also the SEEP requirement as well.
They'd gotten SEEP, would that have been enrolled? And they didn't call you back?
Yes, they would have been auto enrolled because they received SEEP and had a qualifying arrearage.
So they'd have been auto
If
enrolled?
we received a commitment file from SEEP that identified that account, and so they met that requirement, they had a qualifying arrearage, they would be auto enrolled when we ran our auto enrollments.
When did you you ran auto enrollments a year ago?
We ran an auto enrollment. Our prior practice was upon a SEEP commitment file, we would enroll that customer in MPP.
Okay. So staying on MPP for a second, throughout this MPP season, the current one that ran from last fall to now, have you been dropping customers from MPP if they failed to make their MPP payments?
So until recently, because of programming changes that were required in order to program the removal of customers from MPP upon missed payments, we had not begun removing customers until the last
April 18th.
April 18th.
Do you know how many customers remained on MPP that would have been dropped if the programming had been in place?
Yeah, I think as we had discussed in a meeting that we had, we are analyzing the numbers. We're removing the customers by cycle. So we're reviewing, we ran some reports to do sort of an estimation of potentially how many are involved, but we're also confirming that as we remove them by cycle, confirming the numbers, and then continuing to assess the impact of that and any matches that we need to reevaluate.
So if it began on April 18th?
Correct.
And if you're saying you're running them by cycle, you mean billing cycle?
Yes.
Okay, so then can I conclude it's going to end around May to 18th?
Yes.
Okay. So then it won't be finished in sufficient time. I forgot when late file exhibits are. Would you be able to file a late file exhibit on that, or you won't have sufficient information in enough time?
Have to assess the timing, but you mean just to confirm the numbers of removals?
Please, yes. Or the number of customers that you found in your system who should have been dropped from MPP at that time that weren't dropped.
Yeah. Yeah. I mean, the assessment the initial assessment that we've taken is roughly 1,600 customers. But again, we want to validate that through running the actual program. This was just kind of using spreadsheets and some assessment of the components of the account. So we'd be more comfortable in confirming once we run the actual program.
Did your initial assessment find out how many of those that remained on MPP that you matched their payments?
Those were the ones that we match. Sorry, those are the ones that we matched payments.
Okay, so for all of them.
Yeah.
And I assume you're Do you have a dollar amount of your assessment?
An approximate dollar amount is around 150,000. That includes the seat matches that you had asked about before.
And do you, there was a discussion there a second ago about the timing. Will you have sufficient timing regarding to get the data?
I'd have to probably discuss the calendar and
Yeah, could we report back on that? Because we're seeing the May 14th is the late filed exhibit filing date. So I think we have to take it back and figure out what would be available by that date.
Okay. Okay, I will put a placeholder as late file exhibit 4 to confirm the number of customers that should have been dropped from MPP, but were not, and the associated dollar amount of the matching. And if the company comes back tomorrow or whenever and says that you can't provide that, I think we can change it to provide best available information or something. Thank you.
And continuing in the same line of questioning, did you send these customers a communication telling them that they were going to be dropped from MPP if they failed to make their payments?
they were receiving the regular communications, which would indicate that they had missed payments and would be dropped from the program, yes.
Okay. Could you either provide a copy of example copy of that communication, and or if it's a standard communication in 24 or 501 or one of the other dockets, point us to that?
Yes.
Whichever one. So is that?
I can amend the file for to
Okay.
reflect the communication.
Okay. When did you first contract with Alorica?
I believe our very first contract was signed in March of 23.
Okay. When did you contract with Alorica regarding credit and collection calls?
One moment.
When you say contract with them, do you mean, what exactly do you mean by contract with them? I guess I'm looking for some clarification.
So my understanding was the initial contract that you had with Alorica regarded other like not credit and collection calls. Is that incorrect?
So
I'm sorry.
No, So yeah, so the original contract was for MIMO calls only. Open-ended that we could add more calls as we needed. Amendment number 1 signed May 24 is when we entered into an agreement. It wasn't an additional contract or anything. It was just an amendment to the current contract, May of 24.
Okay. So in May of 2024, you amended the existing contract to allow for Alorica to handle the credit and collections calls.
Correct.
And this was as part of the process where you were ramping up Alorica and ramping down, lack of a better word, ICOR.
Correct.
Okay, so turning to those calls, I think if I understood OCC 213, you evaluate 4 calls per internal CSRs per month and 5 for external CSRs?
Could speak to that. Let me pull it up. So internal CSRs, a little bit more straightforward. It's those reviews are done by supervisors. We look for 4 per month, but based on extenuating circumstances, resource constraints, they might not They may go above or below that on the internal side. As far as the external, where we've landed, and this will be documented somewhere in the contract, but it evolved over time with Alorica that we do 5 full evaluations, regardless of time that you've been for EA calls, 5 full evaluations, 12 reviews. If you've been here 0 to 2 months, then it goes down to 10 reviews and 8. The supervisor will do 1 of those a month, and then the QA team will do the other 11. So it's a total of 12 reviews per month, EA only, and then 5 general call reviews for the Alorica rep for credit and collection. And that EA review does go down over time, 10 after 3 months and 8 after 7 months. Like I said, it's a bit hard to explain, but we have special stipulations right now for the EA calls that we've asked for more reviews.
Okay. Is that documented anywhere in your contract with Alorica or with an amendment or anything?
It's not documented this specific, and this is what we came out as an agreement as we were, felt like it was a adequate amount, and I'm not sure we're at that right amount yet. So yes, it will be an amendment at some point, but I want to make sure this is the long-term path that we are going to go down, if that makes sense.
So in OCC 77, you stated that you evaluated 681 total Alorica calls in 2024.
I'll have to pull that up.
That's
Sorry, which OCC?
OCC 77? Let's make sure. Yeah, I'm looking at the attachment to it, and I
want to clarify that those reviews are done by the Alorica employees that we're auditing. And we've also submitted that we've done some reviews. Let me check. Okay, we have it pulled up, and you could ask your specific question again.
So that interrogatory response indicates that in 2024, you evaluated 681 total Alorica calls. Is that, you're saying that's not the correct number? If it helps, Cindy, I'm in column 8.
No, and I'm looking at it, and that's May through November. So those were the amount of reviews that were done, but
Okay,
a lot of people were still in class and not on the floor yet. So yeah.
understood. So, obviously, 681 doesn't represent the total number of calls that Alorica handled in 2024. So how do you determine how many calls you're going to evaluate? Like, for instance, you described your process before about the 5 calls and 12 calls. Like, how do you determine how many calls you're going to evaluate each month?
Yeah, and so, there is no exact science to it, but we want to make sure that we identify at the rep level certain trends, certain things. And so when they graduate from class, they go into nesting, and that's for 2 weeks where you get somebody standing behind you and holding your hand. Then they go out into production. And we just want to make sure for the first few months that they're out there that we're getting plenty of reviews on them. And that's the time where you really determine if they have the skill for it, or is it a will situation. So we want to make sure we get as 12 helps us get to that number and has worked well for us so far.
Okay. So you, based on a graduated scale, you're essentially doing a statistical sample based on a
Yeah,
graduated scale.
It's not a, yeah, you want to do more. And the challenge is it's all manual right now. So you have to balance the time it takes to do these reviews with the amount of resources that you have to do these reviews with the cost. But 12 has worked really well for us so far.
Okay. So trying to understand the process of the evaluation, I think you spoke on this for a second ago. Alorica evaluates its own calls internally, and you evaluate your own calls internally, but then there's also some members of your internal staff that evaluate Alorica calls.
Yeah, and that we have 3 internal resources. And so we want to use those resources very smartly, I would say. So as opposed to them listening to calls all the time, I'd rather have them listening to the QA analysts to make sure that those or observing and auditing their QA analysts. It is imperative that their QA analysts are very accurate in their scoring, or it doesn't do us any good. So we certify a new QA analyst, and our folks, our internal folks will assist in monitoring and observing and making sure those QA analysts on the Alorica side are doing the right thing. And Alorica is fully aware too. It doesn't help us to not have very accurate scoring.
Okay, so I think you might have partially answered my next question there. Your internal staff members evaluate the evaluator, so to speak.
Yes.
Okay. Do they ever evaluate any calls independently that aren't evaluated by Alorica, or they're just making sure that Alorica is evaluating the calls?
They will. It's not as much as a formal process, but we also have vendor management analysts too that manage the program, and they'll jump in and we'll call it a spot check random amount of calls, and just so see if we can see anything. You know, that's less than a formal and documented process. It's let's listen and hear what's going on today.
You also have formal call calibration sessions.
Yes,
right,
in addition.
which basically are measuring if they're measuring the same things that the internal evaluators are measuring, and just assessing and making sure that the scoring mechanism is consistent across all the evaluators.
And so the internal staff at UI that are conducting these evaluations, what positions are these staff?
I believe they're QA lead analysts. And they do more outside of the just EA calls. They do new hire training. They train the quality program. They keep the vendor updated on the quality program. They'll actually train new hires, but make sure that the forms are updated, that the processes are updated, do listening and other duties.
Okay, so what is usually their background of a QA analyst?
I
I would say that each of the QA analysts that are in roles currently were formerly customer service representatives. They were high-performing customer service representatives who applied for management roles and were selected. And they go through an intensive quality assurance training process to be able to score and evaluate calls.
Okay, and same thing at Alorica too, or are they CSRs who work their way up the chain, or?
Well, for the most part, everybody at Alorica was at one time a CSR as we were ramping them up from kind of the ground up. So most all employees at Alorica, either in a supervisory position or in a QA position, was at one time a customer service representative. And additionally, there is a requirement for training staff and QA professionals to do some call handling each month to make sure that they're maintaining their product knowledge, which I think we included that in one of the interrogatories.
Understood. So the people doing the evaluations are people who are accustomed, or, knowledgeable about the information and accustomed to engaging
Yeah,
with
they've gone,
customers in some manner.
they've gone through full CSR training, have spent time in the seat, taking calls, and have moved on to an evaluator role.
Yeah. And
Oh, I'm sorry.
I just want to clarify too that we have 3 individuals, but they support both gas and electric. So we have 1 UI and then 2 that are UIL. So the 3 in total across all UIL companies, but just 1 for UI and 2 others that are partially UI.
And Attorney White, if you could let me know when you get to a good stopping point.
Actually, I was about to turn to a different interrogatory, so I'm at a good stopping point.
Okay, thank you. Very good. Then we will stop here for the day. And when we return tomorrow morning at 10 a.m., we will resume cross by the Office of Consumer Counsel. I have 2 read-ins. We can hold those to the end of this panel tomorrow. All right, thank you. And we are adjourned until 10 a.m.